So, Mr. He was right then. He was telling us he was right. Probably sports quota. So he was right.
He studied for the last 2 months.
All right, we'll take it up. Which you are moving a memo?
Yes.
Day up. Right. Huh? Oh. Day after. Only day after. But this is not final hearing, right?
Yes, sir.
No. Then please move an application for early hearing. Have you filed? Please move an application. We will grant you one. There's no problem. What happened? Did? By whom? Vacating stay. All right. Day after. It's only on orders on vacating stay. Or what? Writ appeal? Huh? Is a writ appeal. Writ appeal has to go before some other bench. You tell him. Whatever. Yes. Okay. Yes.
I have filed without of 2020 for recalling the order asked by this municipal court permitting Rajamma to come on record. Then I have filed down documents that in 2 of 2020. Subsequently,
It's all you are arguing, but it's all non-compliance. It's all non-compliance. And you are arguing this for that past. We will grant them week's time is granted. Week's time is granted to comply with office objections, failing which interlocutory applications which have been filed by the respective parties shall stand dismissed. Whosoever is filed. For disposal or has become what is learned counsel for the appellant submits that learned counsel for the appellant seeks leave of this court to withdraw the memo dated 22/12/2021. Accordingly, same is dismissed as withdrawn. What about Mr. Abatement? This for analogous hearing along with WA number 881 of 2014. Yes. Like 2 of 21, 3 of 21.
First, it will be
Cost, let the cost amended, the cost that will be amended within 10 days. Time failing which appeal shall stand. Without 2 weeks further time failing which appeal shall stand without reference. Seek leave of this court. That permitted to do so, none for the appellant not interested, dismissed for on purpose. Five. How many case? What about five? Not. None. She filed a memo. Committed to retire. None for the appellant. Dismissed. 5.1 and 5.3 into the week. Office is directed to reflect his need. Then early hearing. What is early hearing? 2013. Let the appeals be listed. Final hearing. In the first week of February 23.
Correct. I don't think your notice has been issued.
Oh, connected notice has not been issued. Yes, 5.1. Are what instructions? 3 years. You take to see notice of IA 1 of 20. Yes. 5.1 issue notice of IA 1 of 20 to respondents. List immediately after respondents are served. Don't say then finally. Peremptory. Has been filed seeking leave of the court to withdraw the appeal. Memo is accepted. He is dismissed as weeks peremptory. Weeks peremptory.
For the appellant, my lord.
Weeks peremptory.
My lord, for the appellant. Serial number 10, my lord. That's serial number 10 for the appellant.
Or on IG.
My lord, serial number 11, my lord, I appear for the appellant.
My lord, serial number 10. I appeal for the appellant.
Pending.
My lord, serial number 11, my lord, it may be
IG
passed
is
over.
allowed. Let the appeal be listed. Final hearing on 23rd January 20. Huh? 11 years it is pending, still you are not satisfied. What we are allowing is application. Respondent has died. Huh? Respondent has died. Then what do you want? It is listed for recall. Oh, sorry, I thought that it's early hearing. You recall. So what? Respondent has died. Why? Why we don't need notice. Hold on. Order dated so and so 25/3/20. Arey, why you have
ವಾಪಸ್
not
ತಕೊಂಡು
appealed?
ಹೋಗಿದ್ರೆ ರಿಟೈರ್ ಆಗ್ಬೇಕ್ರಿ. ಯು ಆರ್ ನಾಟ್ ರಿಟೈರ್ಡ್. ವೈ ಶುಡ್ ವಿ ಇಶ್ಯೂ ಕೋರ್ಟ್ ನೋಟಿಸ್?
No. So, subject to payment of cost of rupees 2,000 before High Court. They don't be obliged. Remain present when the matter is listed next. 10 years, 11 years. You should feel accountable to your clients. Right? IA is allowed.
ಇದು ಹಾಕಿದ್ಯಾ ನಮ್ಮ ಬೊಂಬೆ ಒಂದು ಬೊಂಬೆ ಹಾಕಿದ್ಯಾ ನಿಮ್ಗೆ
ಹಾಕಿದ್ದೀನಿ ಸರ್.
ನೋಡ
Okay, so cases have been issued.
Appellant.
He is
Appellant.
appearing, we can allow.
Appellant has died.
Oh, appellant has. All right. 9 has died. Cases have been issued.
Which matter?
12.
Appellant has died. Advocate for the appellant.
Just a minute, 12.
Nine.
Who has died?
Nine.
On that. Oh. these IAs right now, right? IA 2 of 21 shall be considered at the time of hearing of the appeal. I mean, then after, just a minute, amended cost that will be filed within, within a week, then whatever. IA shall be considered at the time of hearing.
Connected matter.
Connected matter, what is it?
That also.
R7 can be allowed, Mr. 12.1 allowed. 12.9. 12.9 also allowed. 12.2 also allowed. On that. Who has died 12.2? R9. Yes.
My lords, I'm for the appellant in this case, my lords. My lords, the
12.1. After hearing learned counsel for the parties and in the light of order dated. Sure about 22/8/2022 passed in WA number 592. Still, you should verify. He doesn't take the responsibility of making a statement. We will be wrong. Nobody is saying one number, he is saying another. You check up. IA is allowed. Let cost that will be amended within a week. Order is already there.
The board matter, I leave it to my lord. We had
My lord, I appear for petitioner's counsel. This is a matter, my lord, is already covered by your lordship's judgment. Bank employees pension, whether a
Serial number
employee is
13.
entitled to
Serial number 13,
pension
sir.
or not.
Sir, this is serial number 13. 13.
Lord, I am sorry.
We were just wondering that how this family court matter is covered. He is looking, the counsel for respondent is.
My lord,
looking
I
at
thought,
it.
my lord, I thought it was 14.
Yes. Yes.
serial number 13. I am for the appellant in this case, my lords. My lords, I pray for 10 days time to report settlement, my lords.
Learned counsel for parties jointly pray for and are granted 10 days time to enable them to report settlement list thereof.
Applies, my lords.
Number 14, CPR
I appear for Ganesh Rao, my lord. I am sorry. He made a mistake.
Is it covered? He says some.
That is, my lord, the bank employees case where resignees, my lord, are not entitled for pension. Your lordship recently
not.
decided a case.
All right. What is present arises out of an order dated so and learned signature in WP number so and so learned counsel, senior counsel for the parties fairly submit that the controversy involved in this appeal is clearly covered by a judgment dated 29th November 2022 passed by this court in the 8134/2012 paragraph in view of aforesaid. So, in view of aforesaid submission and for the reasons assigned in the aforesaid appeal, this appeal is also dismissed. Yes. Getting interlocutory application.
15, yes, Vijay Kumar.
Unmute my.
Jai Krishna.
What direction you are seeking? What direction? IA 1 of 90. That will be considered at the time of hearing. What is IA 2 of 90? You take like it's no longer kids, right? Huh? Ah. All right, on account of influx of time, IA2 of 2019 does not survive for consideration. Accordingly, same is disposed of. Appeal has been admitted. Appeal. Let the appeal be listed for hearing. IA so and so shall be considered at the time of hearing of the appeal, then say let the appeal be listed for hearing. Number 16, the no orders are necessary to be passed on IA3 of 2022 as the appeal has already been listed for hearing. What is it? Appeal is admitted for hearing. Unit counsel for the applicant seeks leave of withdraw IA2 of 22. Accordingly, same is dismissed as on record. Record is there.
It's there.
All right. So it's only admitted for hearing.
I cannot. Cannot.
What recalling? It's totally fine. Subject to payment of cost of 51,000. Report the High Court Legal Services Committee within 1 week. MFA so and so is to fight IA is allowed. What direction? Learned counsel, just a minute. Just a minute. She will be all right just now. Learned counsel for respondent submits that she does not intend to supply a copy of IA1 of 2022. Accordingly, same is dismissed. Arey, mister, where are you going? You took it very seriously, right? Why
Very
should you
serious.
run?
If she doesn't want to give it, we will have to pass such orders. It's not-
You don't want to supply, right? Copy.
She
No,
seems
no,
to
madam,
say
you are a
that-
counsel, right? How many times you must have met that even though I request him to supply another copy, I may have misplaced it. How many times? I mean, you can be unreasonable to such an extent that you should have, what should you have said? That, my lord, all right, I will supply him another copy. You should have asked him, has he misplaced? Started leveling allegations. What is this? Huh?
He is not ready to give. Sir.
So, order
Next
stands.
matter.
Is this for- All right, IA number so and so is dismissed. Fine. Language which you understand. This is unfortunate, man. This is the language which you understand. We have been trying to say something. You are just all the trial court did this, he did this, non-bailable warrant and all. It's all not necessary. If you are not prepared to supply the orders. So he need not be even given time to file reply. He should be hanged because he happens to be your husband, right? Right, sentenced to death. I mean, he should be hanged here only. because he is your husband, right? Today itself. So will he not respond? And don't ever seek time for filing reply in our court. And if you say, we will remember it. Write down her name, Mr. Natraj. Write down her name. Her name. Learned counsel correspondent is directed to supply a copy of IA to learned counsel for the appellant during the course of today. Whose praise warrant is granted a week's time to enable him to file objections. List on 16 January 23.
Number 20. Nanda Kumar Bhaiya. Judge Lazarus.
So unreasonable, right? Yes, recalling 1,000. I quote legal services. Within 1 week.
Number 21. Mahan Bhaiya.
1,000. I quote legal services authority within a week. IA is allowed.
22.
21 matter. Why early hearing? Oh, that day you were arguing. And in that final hearing matter, the counsel took adjournment. And she was so basically they wanted to stand behind you basically. Not ready, that's why.
Serial 51.
So it will be taken up along with 51. What's the issue is similar, right?
Yes.
Fine. 1,000. 1 week. Take 2 points. The blue is restored to 5.
24. Kumar Saman.
Same order. 1,000.
25.
Free from justice.
25.
1,000.
26. Sri Raghunath PM. PM.
Great. Mr. Krishnamurthy. How have you started appearing in MFS? Yes, all right. Changes. What is it? 2022 appeal. What is early hearing? Huh? Huh? We'll consider it sometime next month, so not now. We'll consider your IA for some next month. Yes. IA 1 of 22 shall be considered at the time of hearing of appeal. Let IA 1 of 23 be posted for consideration in the month of March 23. Yes, of course. We can refer you to mediation also, right? Why shouldn't you try mediation? No, there's nothing wrong. Give mediation a chance. You should realize whatever has happened, whatever. We are not giving him a character certificate. We are not saying he's a good man, but you have to basically accept that now, whatever. Mediation, so when will you appear? Tell us. Learned counsel jointly submit possibility of amicable settlement. Undertake to appear before Bangalore Mediation Center. List on what date. The parties are therefore directed to appear before Bangalore Mediation Center on what date? You tell us.
March.
February. It's only January, right? On 9th of January, you are talking March 16. What exam? Your exam is not there. Huh? 20th January. 20th. Why? They can appear through video conferencing also. What is there? They can appear through video conferencing. Whatever, what January 27th, what did you write? 20th January, right? 20th or 24th? 24th January, Friday.
24th is Tuesday.
24th, 20th was Friday. All right. 20th January. 20th January.
27.
What? What do you say? Okay. 561 days. 561 days. 1,800. Just. What happened? 3rd of October 2018, and then what happened? No, so then after what did you do after 3rd of October 18? Explanation for condonation of delay. Ex parte decree.
Actually, expert. He had entered in person.
Oh, I mean, you should thank her. She has not filed an appeal. Otherwise, she would have claimed 5 crores. Claimed 5 crores. See, how do we know? How do we know? Yes. No, but madam, why don't you appear? Just a minute. Appear before mediation center, right? Yes, no, sir. We should not start. I mean, we don't know. Give it a try. What is there? Why shouldn't you appear before mediation center? Huh? Huh?
And only given for admission on the next day. I'll do a second.
All right. Third learned counsel for the parties on IGN 1 of 2022, after hearing learned counsel for the parties and taking into account the well settled legal position. And taking into account the fact that the expression sufficient cause deserves liberal construction so as to advance the cause of justice, common delay of 561 days in filing the appeal is condoned. In the result, just a minute, in the result, IA 1 of 2022 is allowed. let the appeal be listed for orders on admission on 19th of January 2023. On or before next date of hearing, party shall file an affidavit of assets and liabilities. List on 19 January. Hey, we don't know.
Now they filed a exhibition, you can do the exhibit. That is still 19.
You should pay something, right? Can't.
Is a deposit about. Is a deposit about 5 lakhs.
50 lakhs.
Of course, for a entity only up to 19.
No.
Anyhow, I can do what you say. It is difficulty. Anyhow, I don't know the thing is there.
You can manage, right? Why do you need an interim order? We will make you deposit some amount. Why should you then don't? I think it's 50%.
LCR makes an office.
Ah, office is there. What have you told him that see to it that requisition is issued immediately? Huh? That's what you are telling him. Huh?
Once the record comes.
Well, my lord, in serial number 28,
But on IA 1 of 22 and 2 of 20, issue notice record.
29.
Permission.
There is not a any of these two. But there are only that means very correct. And I found that the child is not
Say what permission you want. Plus that he has been admitted. 2 weeks. It requires some time is understandable, but why 2 weeks? Weeks time we will grant, fix the date. Learned counsel for respondent praise one is granted a week's time to enable him to file objections to IA 1 of 23. The respondent in addition shall also annex the documents to show that the child, namely the son, daughter, what's her name? Is prosecuting studies based on January.
Literally, we are thinking the relief that has been brought in the memo by virtue of the application. Where is the player of the one? So they are filing one or the other application. As good as they are speaking for application, following the application. The interest of the child are seeking. He is already uneducated. Yeah, she is in the second discharge of first year.
No, we are not inclined to believe your statement prima facie. He will show us the documents. Which parent in today's world would like that the child will remain uneducated? Mister, what are you talking about? You may fight your battle against your wife. Don't drag the child in it. We understand. Yes.
And moreover, Lordship, this court has granted the visitation right. One day or the other is opening one Sunday to other Sunday. And Tuesday, Thursday, video calls are submitted. When I attend the video call, she will switch off the camera so that I could not see the child. Let him warn me, strictly let him follow the under direction.
Have you mentioned anywhere Just now we have granted him a week's time to file objection. Matter is coming up on 16th, right? What can we do? Number 30, Deviation Kumar, is Kumar Reddy. Not followed. Yes. Jointly submit that there is a possibility of amicable settlement of the dispute. They are ready and willing to appear before the Bangalore Mediation Center. Huh? Learned counsel for parties undertake to appear before Bangalore Mediation Center on 16th January 23 at 3:30 p.m.
31, Rannath Stories.
Issue notice on IA 1/23 record.
For admission, number 32, Narayan Bhatia. Upananti, Story Preacher. Number 1, 2, 3, Narayan. Now the response number 1, 2, 3, Air India has been taken over by the health entertainment.
Well, that's why you are looking at him that please do your job of seeking an adjournment. Huh? No. You when you instead of looking at us, you were looking at him. So you are trying to tell him, please do your job of seeking an adjournment. Like that, right? Huh? So learned counsel for parties jointly pray for adjournment. List after 2 weeks.
Because
The substance is that you want an adjournment, right? What is
He's saying the writ is not maintained.
not meant, not adjournment. Then you said Air India became so and so. So we thought that
It is not maintainable. That's what he said.
the learned counsel for respondent has filed a memo. No, undertakes that, states that he shall file a memo raising an objection with regard to maintainability of the appeal. A copy of the memo has already been supplied to learned counsel for the appellant. Learned counsel for the appellant undertakes to go through the same and argue the matter. List next week. But no. Not the pleading, you have to argue. This is the.
Yes.
No, not, yes. No, nothing. Here he knows, that's why he has sent you. This is most unfair conduct, Mr. We keep on watching. Not fair, I mean, you are just trying to portray, this has been argued by your senior. My lord had pointed out that the appeal at the instance of the employees is not maintainable. Today, you have been sent saying that this, we will not permit these tactics. Nothing. What is, yes, what is the infirmity with rule 4.4 and 4.5 of the rules? What is the challenge? This is it. Why you have been sent to seek an adjournment? Your senior is sports quota. He will be sitting here on this chair. We know sports quota. He sits here from 10:30, and he is not here today. And you don't know anything. No, it's dismissed. Dismissed. No, nothing. It's being dismissed. No, not fair. This is not fair. We observe the conduct of the lawyers, and we really, it really hurts us in telling. We rely on you are just trying to pass the buck. If we would not have read it, you had succeeded in your tactics. What in pleading? We had raised an objection. We had told them that the writ petition is not maintainable. We are asking you, forget about maintainability. You have challenged the validity of the rules. What ground you are challenging the virus? Tell us. Learned single judge has held that the rules do not suffer from any excessive delegation. That's the ground of challenge. What tomorrow and senior?
Police are not party to the writ.
And you are not party to the writ petition. Not fair. Don't be a party to tactics played by your senior. You should say that I won't be a party. Don't say you are spoiling your reputation and career as a youngster. We will remember you that you are an unfair counsel who was trying to just mislead us by saying that I have filed an application for impleadment next week. Nothing. No. What makes you believe that if you file an application for impleadment, the case will be adjourned by 4 weeks? Who has told you? We are asking you to argue the case. Argue. Also, remember, Mr. If you don't come, the order will be passed on merits. Don't be under any impression that in your absence, the court is helpless. Nothing. Just now, within 5 or 10 minutes in passo round, it will be called. If you don't turn up, we will pass an order. And we will record all this. That you have deliberately disappeared. We will say, write something in your praise in second round. If you up to some mischief, right? There's no question of passo. You know that what is the point involved. No. So if a sports quota case comes, he will be ready sitting here from 10:25 till 4:45. Then filing review petitions and this. No, not well. Nothing. He is not well. In any other case, we would have granted an adjournment, but not in this case. It has a history. He has argued this case. He knows that the bench is not with him. Then he sought an adjournment. On that day also, we told your senior that this is not fair. Then you have been sent. Whether these employees have purchased you, Mr. Huh? Have they purchased you? Huh? We give you put you on a much higher pedestal. We treat you as officers of the court. And this is how you behave. What has he done? I mean, has he purchased you? No, Mr. No passover, because nothing will happen in passover also. In 10 minutes, it will be recalled. You won't be there. Mark the place. Nothing. Appellate number 1 has withdrawn.
This is the appellant institution. This is the appellant 2 to 4 have been dismissed from service.
Yes.
That's what.
Fine. Mark it. In any other case, we would have adjourned it, but not fair on the part of your senior. Not fair. It's intra-court appeal. And 2019 appeal, just like waiting for the bench to change, right? It's all tactics. 2 weeks, I have filed an application for impleadment. Why don't you know it? What is your, are you on admission merits? Impleadment we will deal. If the appeal survives, everything else will survive. No, nothing. No. This intra-court appeal has been filed against an order dated 25/4/2017 passed by learned single judge, by which writ petition preferred by the appellant.
Not even party.
All right. By which writ petition preferred by not the appellants, writ petition preferred by one Rajeshwari Vidya Sansthe and its employees challenging the validity of Rule 4 and Rule 55. Rule 55 of Karnataka Educational Institution, in bracket, change in the governing council or change in the location of private educational institutions, bracket close, Rule 2006, as well as circular dated 20th/10/2010 has been dismissed. Paragraph. That's giving rise to filing of this appeal. Briefly stated are that so-and-so institution as well as its employees had assailed the validity of Rule 4 and so-and-so inter alia on the ground that the provision is ultra vires as it suffers from the vice of excessive delegation. Learned single judge has held that the object of framing the rules is to prevent and discourage the institutions from seeking change of location for commercial interests or in order to somehow continue to exist, even though they are not in a position to comply with the regulations and rules with regard framed with regard to infrastructure and other resources. Full stop. The learned single judge, by placing reliance on a decision of this court in Vidya Sansthe, Bharat Vidya Sansthe, Vidya Sansthe within bracket registered and another versus State of Karnataka, ILR 2008, Karnataka 4406 has upheld the validity of the rules. The learned single judges further held that that the circular dated 20th/10/2010 has withdrawing the power conferred on the Commissioner for Public Instructions of respective jurisdictions of private and secondary education, and to authorize these the state government to approve the change of locations to change of governing council with the state government has rightly been issued. Full stop. Paragraph. As stated supra, the petitioners are as stated supra, the appellants are not parties to the petition. Full stop. Learned counsel for the
Appellant number one is appeal was withdrawn.
the appellant number one, namely the management, has withdrawn the appeal. Full stop. Learned counsel for appellant number one submits that the services of appellants 2 to 2 and 2 to 4 have already been dispensed with, and they are no longer employees of the institution. Full stop. Paragraph. Even otherwise, the rules do not suffer from any infirmity. Even otherwise, learned counsel for the appellant has not been able to demonstrate as to how the rules suffer from any infirmity warranting interference of this court in exercise of this intra-court appeal. The appellants 2 to so and so have no locus to challenge the circular dated so and so, dated 28/10/2010, which has even otherwise been issued in conformity with the rules. For the aforementioned reasons, we do not find any merit in this appeal. The same fails and is hereby dismissed. Pending IAs are You did not hear the order. Huh? Followed. Did we not say that appellant number one has withdrawn the order? This is too much, Mr. That after dictating the order, we should explain it to you. What is the order? Please focus on the appeals which you filed, right? Instead of entering into this. It's already concluded matter. 2:30, you will be supplied with the copy. You will get the copy at 2:30. Book your tickets northwards, travel. Don't appear. We do not like the tactics to be played with the court. Always be fair to the court. We don't appreciate this. 34, appeal is admitted for hearing. Record
Settlement.
settlement. Admitted for hearing. Record. Admitted for
Yes, my lord. I'm the appellant, my lord. My lord, appellant filed this petition for divorce, my lord, under Section 10 of Divorce Act, my lord. Trial court dismissed the petition, my lord. My lord, 26 years desertion is there, my lord, in this case, my lord.
Next, 27. 36. 36 what?
But yes, Nagesh.
36 admitted for hearing. Corrected case what you will?
Yes.
Okay. 30, no, not direct. Issue.
Same judge.
Undertake 36.1 undertakes to take steps for on respondent within a week.
First matter, there is a stay.
First matter, there is a stay. 8207 interim order shall continue.
Number 37, the case registration matter. Mahesh.
Admitted for hearing record. Notice to whom? Appellant.
Already issued.
Acha, already issued, yes, none for the appellant despite court notice having been served on
Name
the
is
appellant.
not shown, sir. Name has to be shown in the court.
Acha, office is directed to reflect the name of the appellant in the cost type. List day after tomorrow. Call list. Call list day after tomorrow.
Number 38, R. Madhusudan Reddy.
And seeking leave of the court to withdraw the appeal. The reasons assigned in the memo. Appeal is dismissed as.
39, Ismana Nagara. Now,
Why? But you are not inconvenienced, right? Nothing great about this is all settled, right? Huh? Hey, what no instructions, mister? How can the council you say that I have no instructions? You have only, and supposing if we refuse to grant adjournment, what happens? It is left in this destiny. And then you will tell, I don't know who has made them judges. They don't understand anything. Corridor, right? Tell us why adjournment. What do you know about the case? Great counsel for the appellant prays for adjournment on the ground that arguing counsel is unwell. Just after 1 week. Interim order if any shall continue. We would like you to get ready. We have granted an adjournment. You can't have it like that. I will only argue on 19th. I will only argue at 10:30. Or I will argue only at 2:30. Before that, I will not even come to the court. It can't be like this. Everybody, including us, have to be abide. We have to abide by the proceeding, right? Not like 19th. Then on that day, you will say, I will only come at 2:30. Friday, we waited for a senior counsel. He didn't come. His juniors also didn't. It can't be like this. If you have so much of difficulty, leave the case. Tell the client that I can't appear. I have difficulty. I am full of difficulties every time.
number 40, Irfan Nazir, Prakash P. Hebbar, government advocate.
what you are praying for time, nobody is for the appellant. And for the appellant, learned counsel correspond number 5, praise for adjournment. List in the next week. Next week. Oh, yes. So, Mr. Yes. Huh? Oh. So, delay of. He should come here. Our communication with him will be much faster and effective, right? He doesn't respond to your communication. Why trouble him? He has been last week also he came for this case. Today also the deputy commissioner has no time. Will some call him here? Deputy. There's no re-grant. Please see your options. Updated 1/8. Yes, heard. For the learned paragraph marked, this petition has been filed seeking review of the order dated 12th of April 2022, passed in WA number 300/2021. After hearing learned counsel for the parties and on perusal of the record, we find that the grant in favor of the review petitioner was cancelled on 28/6/2004, which was challenged in a writ petition. Full stop. A learned single judge of this court by an order dated decided the writ petition. Thereafter, the land was restored. Thereafter, the grant was restored in favor of the review petitioner on 28/4/2010. Full stop. It is thus noticed that there appears to be a delay of 6 years in filing an application seeking resumption. However, a aforesaid aspect of the matter has not been dealt with by this court while passing the judgment dated so and so in WA 300/21. Accordingly, order dated 20th so and so recalled WA restored to file review petition. Number 42. Appeal is admitted for hearing issue notice record. Acha notice or don't admit it, issue notice. Records. Record. Appeal is 43. Appeal is admitted for hearing. IA 1 of 23 after hearing learned counsel for the parties, comma. The operation and effect of judgment and decrees so far the parties dissolution of marriage shall remain state record. The learned counsel correspondent may file objections to IS so and so 1 of 23 if so advised. Then see. Yes. 44. Appeal is admitted for hearing this on IA 1 of 23 issue notice on main as well as IA 1 of 23 record. 45. Appeal is admitted for hearing issue record. First over matter, bill number 17. I cannot. Was he there? No.
He was there.
And for the appellant. Respondent awaiting appearance, hearing referred list next week. Made clear in case no appearance is made, appropriate order shall be passed. Then say list next week. Number 22.
That will be taken up along with 51.
All right. 50. Number 46.
ಎಲ್ಲಿದೆ ಇದು ಲಿಸ್ಟ್ ಎಲ್ಲಿ ಹೋಗ್ತಿದೀನಿ ಅಂತಲ್ಲ
Lordship, is it 48 or Lordship?
46, sir.
46.
Hey, don't encourage them. It's not meant for this external market. Mute them. It's not meant for that we should answer them and they are sitting, they will put questions to us. It's not meant for that. So their facility of appearance, they are not supposed to put questions to the court.
And hold.
No.
There is no virtual hearing in any other. One in Supreme Court only 2 days. Entire country only we are here. And we are even this type of facility. There is trouble.
Yes, Mr.
Only this. This has to be kept.
Yes. Yes.
And meanwhile, he can feel that the environment is developed. Education rights can be continued at a complete and legally approved and documents. Brief. For the internet magistrate. Of the charge sheet. The complete certificate. And testimony of the investigator, witness, is there. Kindly please. No, we are. Let's say, family photograph. Together from pages 628 to 651. Set of photograph. From 653 to 656. And the 658 660 to 664 and 666. That if you look at clearly from page number 3 onward, what you may kind of see. Kind of see the word edit there. If you look at fine. The word edit there. Also on one more, two more photos, 66 and 60. You have specifically taken this contention. Our contention has been detected on the ground that we did not see in the forensic help in this. When we raise the contention that there are marked pictures, the court will have referred them to the expert. That has been just rejected outright. It is possible, with the help of the software available, that one picture can be imported into another picture, or if one picture can be exported into another picture. Even the face can be changed. This can be solved. Therefore, if that cannot be relied upon, that be rejected. Then the next submission is the email. In the email, allegedly sent by his father to my father and copied to me, which is the page number 886. Confronted me. Whether the email ID appearing belongs to me. In the email, it is as if I am prepared to give up the child for the relationship to continue. Do not confront. But in this regard, what it may say, page number 1366, volume 3.
1366.
Examination. Correct. 7/2/21. Page 1366. Whether this email is the correct one, which one has kindly see last. It is possible to suggest that instead of spending time, I have spent hours together with Shivan. The email ID is single enter. It is good to suggest that exhibit P17, that is this email, is my email ID. I have admitted that that is my email. Subsequently, got to the alleged apartment taken on lease in March, April 2018 by Shivan Adania Corporation. There has been the required before you are running the rate upon a bank statement. There is bank account of Shivan to substantiate that Shivanan paid 75,000 rupees for the advance of the apartment of Agarwal. And on 3/4/2018, we also paid for 14,500 towards the rent. Except those entries, there is nothing produced. Show that 75,000 rupees was the deposit for the apartment and 14,500 rupees was the rent. And the learned counsel wanted to believe that this 75,000 rupees paid to Amita Agarwal by Shivan represents the deposit amount that was paid on 13/3/2018 and 14,500 paid on 3rd April 2018 represents the rent. There's nothing to show except the equity. Oh. Let me know the cross-examination. The appellant has been read put up. So that's kindly to volume number 3. Suppose my learned friend has argued that in one place I read, I don't know who is one, I don't know where he, and still I have carried on with this. Without taking the entire paragraph, in some paragraph I have been there. I would request you are asking kindly to take volume number 3, containing the deposit. Because volume number 3.
Which page?
Page number 1321. 1327. And page number slightly not taken. Yeah, paragraph 57. The first sentence was right. I do not know where Shivam referred to in my observation, paragraph 41. This evidence was recorded at 20th February 2021. We must understand the context of the date on which it was recorded. I do not know where Shivam referred to in my observation. Thing was working in Columbia, Asia, Margaret, and Bangalore. It is false to suggest that the red card community was working in Columbia, Asia, honestly, on New Delhi. I do not know the father with whom I wanted to do. I do not know what he is doing. I do not know his address. He is not there. I do not know his telephone number. That Shiva is married, as he was my colleague. I know that he is married just like my other colleague. No, I joined Columbia in Asia on 16/2/2016. As on that day, Shiva was present there. I do not know when he left Columbia. He had accepted or what is his telling before. This is the Shiva along with the thing in Taiwan. As on that day, one sentence we cannot take out of it. As the date this evidence is recorded, Shiva was not working there. And she says that she does. Then we learned about to page number 138. 59. And he is in charge of legal services and legal quality. Whenever all three of us joined collaboration, I got and the contract with people. It is possible that the as per the said contract, we will not propose to set up the then you will have to candidate or do next page, 1329. And then starting for the he alleges that I have not obeyed the order of the what has been done. The order of modifying the visitation type. I distribution. I did not obey that, and therefore, consequently, the content of court case was filed. So that I'm explaining here. In the content case, non-payable one. Was during COVID time. And the petition, the office has been stopped. And therefore, you are non-payable one was returned to the police, payable one. The police is saying that she said she has COVID. And there is no possibility of my being in the hospital at all. Hospital office has been closed. I was working from much has been done. Then subsequently I appeared and I apologize. So that cannot be very different to me doing COVID time. And all the hearings were held by video conference. But here, internal page 1329. It is good to suggest that he alleges that I have not obeyed the order of the party. It is good to suggest that I have filed a affidavit for unfailing apology. 28/2019. That is in the contempt. But I have also clearly stated that it was not me who disobeyed the order, but as the petitioner herein abused the child did not wish to visit. Then it is true to suggest that on 14/8/2019, the article of High Court of Karnataka did not close this effort, because what is the ground of the advisor get all the different
come here from this book. Yeah. Come. 1331.
133.
Yes.
Question, answer, second answer. It is incorrect to say that as per English PG, page of 296. The English PG is the charge sheet and all the accompanying documents there. That is the hotel bills, hotel invoices, etc. English PG, at page 296, 901 room check. They check into early. There's a very careful. Then we got Right. Photo have been hacked. 855. Page number 1334. That's like that. Then the photograph was hacked. Mark the photograph. Then turn on the one. State. It's subordinate of this respondent. Working in the same.
No, hacking is something different. It has been hacked from my phone.
Yes.
Hack means taken from your phone, right? It's not there.
It is not.
Please read para 65. It's not there. It's only hacked.
Then, April 3 has produced a number of photographs with the car of Shivananda Park in front of the apartment where I denying that the car belonged to me. My case for the court was that I had borrowed his car. His car. My car had broken down and there was nobody to attend my car during the COVID period. I had to shift the after shifting the beginning back, changing the gate residences. But we are, that people send people to take away. I cannot do that. I had to shift the various things into this. I have borrowed his car. I'm not denying that his car not there. I have produced the document to show that it is R12. My car was attended to by the garage. Subsequently, R12, I would like to find out because in volume 3, page 1677. Correct, sir. Okay. I am not denying.
Yes.
Specifically denied that one specifically denied that you are 70 of examination. Page number 1336 and 1337. The father had a double bedroom with the NCC office. His father had a 8 days or 8 days along with the daughter and she was. I did not bring it up. But I wanted to go to Mediation and I have a president to I do not know to disclose whether the area of the take my own and the father that is the one who was taking the already today, NCC office has given false statement. The reason we ordered in one period for 7 days and he is supplied with the many matters when the charge sheet for you. This is what they are. The constable who visited he had carrying a photograph of my photograph, Chiman's photograph, and the child photograph. He said so that the photographs were shown to this book and he affirmed that they were the people. But candidate is the I was the candidate to give me this time. So that it record. I am sorry for that. Two below.
Yes. There is a win now.
Report the subject to the constable Ramachandra. He was directed to go to Mysore and make inquiry whether they stayed in the NCC guest house and who are they. And he has given a report that all the three were staying. According to the inquiry. And then the next page is 827. It is section 151 statement made by Gurudev. We spoke to that. Three state that. And it applied the breakfast in the morning, and lunch, and dinner, and afternoon. And he was shown photograph. And he of course, yes, these are the things. These are all
Is it the child? Where is the child? Where is the child studying? FRIT 4. Yes.
The child in the school. I could not disclose the name of the school. I'm not prepared to give the name of the school. Initially, the child was happy to go happy there. That actually I'm playing two years. And gave the set amount to net banking. The reason given by her, the attention, to Maybe right or wrong. Shown Russia. This is part of the question with regard to the email there. With the alleged intent that she wants to an father and copy sent to me. Saying we very I also said that I have prepared to you. Start 41. Page 42, paragraph number 1. Petitioner is working as a doctor in the pathology department of the Hospital Institute of Science. He is residing in Calcutta and South taking a of some important work. Suddenly came over us. Patients, you come home with me now. If not, she abused the as the patient also attended him of their consequence. The petitioner's parents did not leave the house after the witnessing the emotion created. The after petition, the issue of the informing does not his family to be living in the same house, and she was not the statement was repeated again. Again, take up the pen, post of the child. I submitted on 2/4/2018. The petitioner called me over the phone at about 9 in the night. Informed me that his mother had put the food. Respondent picked it up at 5 a.m. So, whole day, the petitioner and parents, clean, captured things all over the house. Returned to the children to the house. I told the petitioner to try to manage the situation. Petitioner tried to face problem because the very next day, the petitioner he said, both he and his parents going to be by one Shivana, then reach the station. That the petitioners would extremely bad before the situation is started. This Papa informed me that the child, and the child was poor, and the tutor will check out how the back. Later, I was informed that the petitioner came to know that she is the was there. The police station, one was there. They heard the fact. It is I have also observed that Shivan and have came over on multiple days at her residence. And car was parked here, they responded to the resident for multiple days. I have seen the responding Shivan and the same and few others. Then you are not we go to. Shivan, that is very next complex of his rest. 50 class new people in the situation as a couple along with the traditional one thing is clear in this affidavit that the PW3 first picture right from the and he was the department. Kindly does the page number 456. Number 8. I'm taking a look at it. Wow. Sometimes I take a Canon DSLR camera while going for parking. It is false to suggest, even though I never put Canon DSLR camera while going for parking, I am before the stall. It is false to suggest that I have mounted a CCTV camera exactly facing the respondent's car. It is true to suggest that between my house and the apartment building of the respondent, there is only common. Now we have copy of the photograph is confronted to the witness, and you admit that the grill visible are part of his house. Car visible in the said photograph belongs to the respondent. It is also suggest that both CCTV cameras installed at my house facing the apartment. I do not know if it is shocking. You continuously follow the I never personally used to see the respondent. I never took photograph of the respondent and one to one. There is no impediment to take photograph them if they come in. According to me, what is meant by parallel eight, revolution, these the background is one with the past. I want to give up another steps. There is no authentic evidence to such one that he because of the affidavit is it that he did that. Now he is that he has no information. The authentic evidence. All to suggest that there is nobody in the science part of the case. Then, 11. During the COVID, he said, he fought. Correct. During the with the child, and the child was screaming and shouting, and his child was there. The parallel evidence report is motive to use this evidence. It is false to suggest that the not in and me as a performance for good. It is false to suggest that as traditional angle with me, I retain the job. It is false to suggest since I am willing to give particular support, the traditional required, and this is false to me. The proof that God installed the CCTV camera, the president of 5D compartment and the workman shifted. Husband shifted that I am invading the privacy. Here the CCTV camera directly facing the apartment where I was. I installed the camera in April or May 2020. Also, the I do not know whether the responding car was completely broken down during the entire lockdown period. I do not know that the said car was taken for repair 6620. I do not know that the car was broken down. She was using the car bearing number KG03. There is a witness who is interested in the welfare of this box. So here given this false evidence. Then Milord Mayana. Other submission that the family court has totally ignored the evidence given by all One, please, sir. That's seven. Says that I am Ekta from March 2014. When she was review writing of the relevant solution. HCG. I was on my notice period. I was trying to paper. I started with tenure. And one. We started my tenure in Manipal from 2014. And that is when we started advocating. I was responsible for managing the medical services. Quality of
Keeping.
keeping, there is a code and seal on all the pages. Keeping very unbalanced during that. And like, May 2015, it came to me on the breakdown without abuse. After the health of their life. Since I had a beach there, the lunchtime, we saw some again, cabbage. I saw our value twisting her hand and pulling her hair because she gave me a simple idea. There is a something. She called that feeling really bad. There are I left their house to avoid any more escalation to happen. Somebody called me that never after 3 months of my delivery, the instant came to my office and many parts looking for a job. And the husband was pressurizing her to earn again. That time, my colleague told me that it is not a good idea to consider take up a job. The husband works being company, and they all had heard her story. And conflict thing for a game. This was the second time. Third, one new. I had bad marks are golden thing on dried ice. You can be very responsible officer. Outside of the faith. During this time too, we still start out with the 2 marks of being the criminal for the arm and for our alone. We can't be player and then after she would like saying she fell out. Whoever the doctor makes it, you need to make it the injury. You can be calling and hand against like I will keep hearing about her community violence issue. Mediation, pardon me. He said that we were the one who had to pay 2 lakhs of money from her. We couldn't help. And she could return it back to my by paying monthly EMI. We also directed her. Like, He had said that he was present on one or two occasions when they checked into the door. That we listed from this. But there is this entire examine in the affidavit. You can see this. Fine. Important of the mother. And this one will go. The judgment is dated December 2021. I said, and there's no second way. Is there an go? Page 8. The question was child custody. The father had married. There was a stepmother. He wanted the custody of his child. The boy spoke. But the family court rejected his prayer. And paragraph, second paragraph on page 8 below, this is what the Lordship has said. This is not to cause any restriction on the help others in general. It's exclusive. When it comes to the welfare of the child, when you have together on the same side, there is a presumption of true, because it has to be common good of natural events, human conduct, their relation to the facts, the case, and the child. For the rest of technology, what a biological mother means to a child, that the quoting to my mother, 1849, is very meant by a American poet and book. The poet is reproduced on because I feel the ever evolve, the angels people into one another, and find not here, burning in terms of love, none so devotion
Yes, sir.
Photograph and said, the lordship see the word edit, so you take a screenshot, you could edit. And there are cross-sections required note, she says this photos my daughter hacked from my phone. So screenshots, that one. Secondly, page 260 of volume 1. When I produced all these documents, I filed form 60, affidavit 65B, and the other side said, no, the documents were taken on page 260, volume 1. Then, is there a second? Yes, filed the order 714 plus 65B. Finally, one last thing. Like the Mysore trip. One page 885. 885. You raise that. They are screenshot. They are screenshot. I have raised the calculation. 885. Appellant writes to Swana. You can talk to Arvind, land I have spoken to. You can say Captain BBC this one other friends. So what happened was they had applied for paid after 7 days they disappeared there. He didn't join 14,000. On 11th of August, the police said, how will they? Anybody there who is taken for it? But here, it shows that Shivaram had something to do with the place. He writes to and what was the question? I give them one book. I have access to one book. That was the okay. Wow. After any of and there is a regular petition going on in the party. Where the project done. There you not hear said specifically in the evidence that he did not find any call having been made by the attorney. Document, there's nothing after what is very document to get it.
Reserved for judgment.
Hearing the matter. All intensity or unnecessary, we will get reduced. Hearing, we can, the end of the hearing. And the last 4, 5, 6 years. Yes, yes.
Hearing number 47.
What? That matter. Auction. You have the record, madam, with you. In respect of my last 2 XABI, that is 1989 and 1988. 2 XABI. What you have written 82, 83 and 83, 80. And then 83, 84. What 98, 99, not 83, 88. 88. That's it. Yes, sir. Just a minute. Just a minute. 1 minute. 82, 83 and 83, 80. What is the amount, madam? All right. They issued notice in 1989, 1989. Their proclamation published, it did not take place after your passport. Hereafter, in 2006. Hey, Mr. Your dates are not correct in the whatever you have said. Here you have said 15,388, you are saying 89. Dates are not correct. Thereafter, you have written 15,388. You are telling us 89. What is 15,388 then? If you have given us this, we are looking at it. $15,388, correct, right, madam? 15,388 sale notice was issued. No. This. So 22/12/84. No, Deputy Commissioner, what passed an order? What? So then what happened? No, this 22/12/84 was the challenge. In- What happened? When? No, when the interim order passed, when? So petition was dismissed on. When was the writ petition dismissed, Mr.? And no action. So you tell us, madam, he doesn't know when was the challenge, when it was dismissed. Get the record, Mr. 17754 of 83. Can you get it?
Yeah.
83.
What was challenged in that order of Deputy Commissioner dated? How 1984 order can be challenged in a writ petition of 83? Order. How 84 order can be challenged in the writ petition of 83?
It is arrears of payment amount due, excise amount challenge, not the sale notification.
Nothing to do with the sale. That has nothing to do with the sale then.
So it may not be relevant, right, for this to decide whether his property has been sold in a auction in accordance with law. How is it relevant that what happened 83 to 88? Mr. Get the record. Any idea about previous litigation? No. He says 18/7/89. That's what I mean. It's all leading up to. He also doesn't know Madam also.
Yes.
No, Mr. Are you not ready? Are you not ready? Huh? Not ready, right? I am ready. But you are from beginning you are making mistakes like you didn't tell us correctly 82, 83, 83, 84 also you didn't tell us. You said some different year. Then you have written in this synopsis 15,388. You are skipping that date. You are jumping to 89. So we are looking at what you have given us. If you are not ready, I mean, it's better that, I mean, it's not our baby, right? We don't have to, unless we assist it properly. I mean, it's not that every case we should decide on our own and you will not do anything. You should have told us in the beginning before handing over that, I'm sorry, I may be permitted to correct.
Secretary
Huh?
to the reports, sir.
You go through the record.
Have you gone through the original records?
Despite that, this is the outcome. Wrong dates and all that. Then if actual disputes, then you should not have written all this. 15,388 sale notice you have said. 18,7 sale. Hey, don't. No. Hey, it's not government's appeal. In the appeal. No. In the appeal which they themselves file, they don't prepare synopsis, so it is too much for us to ask for synopsis in a case where with which they apparently nothing have to. I mean, I don't think. And so what happens to this date should be struck out 15,388, nothing. I will mail it again, any partner. 18,788. Though it was issued, they did not take any action to get. Have produced this release translation at page 19. Here are with the next key. Page 121. This is page 119. What happened sale to sale proclamation? On 87/1989, whereas they did not proceed further and they kept quiet. They did not receive any legal response thereafter.
Their proclamation was after issuance of the.
He is saying that it's not correct, Mr. Ravi. You should at least give us correct dates, Mr. This is the bare minimum. You are saying that we should score it out. He's saying 15,388 sale notice was issued. Notification I have produced there. He doesn't want. Why don't you prepare a synopsis? You do it. Or tomorrow.
Yeah.
What day after? Tomorrow. This 2009 matter. Nothing, right? He will help you. He will do it. We are sure he will do it. Yes. Tomorrow. Get ready. Madam, please see the record, prepare a synopsis, right? No, madam, that's all, it's not relevant, right? So for. So then please prepare a synopsis and give it to us tomorrow. Please prepare a synopsis. If you want to rely on any dates and this thing, please. Tomorrow we will take. Don't say anything, it will be repeated.
Yes, yes.
Find out.
I inform you.
Number 48.
I appear,
Government advocate.
I appear for petitioners, appellant, my lord.
Yes.
Yes, my lord.
Yes, Mr. Panindra, what is it about? Just I want to know what is it. In the meanwhile, he's taking out bulky paper books. We want to know out of curiosity what.
My lord, may
I will just he's present. So. Oh. All the regulatory certificates. Valid or not. It was the European was what's the relate, right? Industrial dispute was tribunal. Even they were rented with the fight by us. Actually, not recovery certificate. There were four entries. For regarding the other. All those all those are the only issue was regarding the various. I mean, the existing development that was pending, and I came to the right. They should deposit the. Is I think you know directly the purpose to deposit the amount. That was challenged by the union because it's not been put by the registry. I think that you know that ID is not directly the ID to be put. There is not deposit the amount. Matter came up to the division. Nothing virtually remains. The ID is closed. ID has been found. All right. On the other hand, you must go into the validity of the certificate. Which cannot be. All right. Yes, sir. Yeah. Yes, they are right. All the judgments they rely on related to validity of the settlement. All. We'll hear it. Yes. Yes, Mr. Rao.
I have given, my lord, your lordship as a small synopsis, my lord. Your lordship can have a. Lord, my lord, this is a case where the management's subterfuge methods by which, my lord, the workmen have been cheated for the last 20 years. That's all. It's a short case in that way. My lord, despite law, workmen, my lord, can be, that is how they can be denied all their rights. They can be made to starve. They can be.
Good to see Mr. Rao, angry young man in New Year. Yes.
Fortunately, my lord, that is my lot, and
So this synopsis you have given, right?
yes, yes. Your lordship may kindly see I have given the list of dates. It is not now the only question, my lord, in brief is, my lord, he.
So please take us through the dates, right?
Yes, yes,
We
yes.
have not gone through your synopsis.
My lord, one is in 86, my lord, this was a cooperative sugar factory, Shuruguppa. Did your lordship get that synopsis?
Yes, yes. Yes.
It was a sugar factory.
1 minute. So there are two synopsis. Which one is?
I have given it, my lord.
Separate.
This is 4-1. I mean, later, only last week I have given it.
5th January, this is the test.
My lord, I have not received a copy of that, my lord. I am also appearing for the respondent.
Synopsis is for our benefit, not for you.
Much obliged.
You haven't read the case. Huh?
Much obliged.
But what are the facts?
January 1.
It is for our benefit because we have to write judgment.
Much obliged.
If you write the judgment, we will give you all synopsis, everything.
All right, my lord.
Paper book also in order.
Paper book I have, man. Paper book I have. Paper book I have.
At your residence along everything.
Paper book I have, man.
It is for our benefit because we
Much
have to
obliged.
write judgment.
Much obliged.
To cut short the time, right? Yes.
What happened was, my lord,
One Mr. Rao, we have got only one copy.
Yes,
Checking.
only one set. That is why office of.
ಒಂದೇ set ಎರಡು ಕೊಟ್ಟಿದ್ದೀರಾ?
Hey, you have filed only one set, Mr. Rao. Hey, this is not. You have to file. We can't look into this.
My lord, I am sorry. I think there is a mistake, my lord. I'll give it in the afternoon, my lord. One more set.
Yes, afternoon. Yes. Give it. We will take it up in the afternoon.
Yes, my lord. ಇನ್ನೊಂದು copy ಕೊಟ್ಬಿಡಿ.
I'll have a soft copy. I'll take it.
Number 49, Ravi Deshpande, J. Kumar Bhatt.
Also,
Number 50, Ramesh Jain. Albert, who is next?
Then we have not restored full funding of the property. He also takes responsibility that he married a queen of king.
so he is demanding maintenance from you. He is demanding maintenance from you. Unable to maintain. Who has remarried?
and 9 for PPC. There was no divorce, there was no restriction of marriage right granted. Family. Against that, this came up as the restriction of marriage right, and they did now find a proper that I have tried 24 and as well, and also made now we are and we have already remarried. Take the extra as they are remarried, I also that it's on board directly to file second.
What expert? It has been dismissed, right?
Yes, in subsequently dismissed. And he has remarried.
Tell us the facts, mister. When was it allowed? When was it dismissed?
Told us who has filed an appeal, what has happened, nothing. Straight away, like statement and this thing. We wish that we could write the judgment in which you are arguing.
Marriage was man.
For the husband, right?
Why?
So petition has been dismissed, right? Then Section 9 of
Before that, he was placed at birth and it was allowed. Immediately after allowing, he has married. Thereafterwards, he sought for recalling the ex parte judgment. Out of contest, it is. Just tell us the facts.
In 2006, marriage was. After that, the husband approached the family court without knowing, without giving any information. Obtained the ex parte judgment and thereafter got remarried. Before the remarriage, I have given a criminal complaint where the police have not taken the complaint, stating that there was already divorce.
So what you are either, Mr. You are not ready or you don't know the facts.
Yes,
These are the only two inferences.
no.
Marriage between 2006, then filed a petition without knowledge and decreed. So when the marriage 365 days are there in a year, when marriage you don't know. Then when the petition was filed, on what ground it was filed, you don't know. When an ex parte judgment decree passed, you don't know. Just like, is it a storytelling,
No.
writing an essay?
And dates are given. On 10 to 2006, 10 to 2006, marriage of the petitioner and the respondent hearing as summarized. On 7/3/2007, husband has filed MC petition. File 39 of 2007. And obtained an ex parte judgment of 1/8/2008.
What ground?
On the ground of
What MC petition? What
on the
seeking?
ground of 13, 1A and 1B. 1A and 1B.
What is that 1A and 1B mean?
Cruelty and desert. And 1/8/2008, he obtained an ex parte judgment. Thereafter, I filed miscellaneous petition on 26/10/2009.
When was the ex parte judgment decree passed?
1/8/2008.
1/8. Then what happened?
Then 26/10/2009.
So on both grounds, this was allowed.
This was allowed.
Party judgment. Desertion, how it could be allowed, it is not.
He states that on July.
The marriage has taken place on the month of February 2006. Petition has been filed on 7/3/2007, within just about a year. How can there has to be a desertion for a period of 2 years, right?
3 years. 2 years.
No.
has to be.
So this is not motor vehicle appeal, Mr.
Yes,
33% disability, not like that.
On the ground of cruelty.
Huh?
Allowed on the ground of cruelty.
Really. It has only been allowed on the ground of reality, Mr. You don't know anything, right? Huh? Not provided. So
Correct.
what happened?
And thereafter, my lord, I filed a miss petition 82
No,
of
no, when this
2009.
was set aside, Mr. Ex parte decree, when it was set aside.
It was set aside on 5/11/2011. 2011. Thereafter, I filed a counter under section 9 for restitution of conjugal right before the in MC number 539 of 2007.
When did you file?
Twenty-four, 2000,
22.
24, 1.
So
Thereafter, for the claim heard and disposed of on 7th February 2013 by dismissing both the petitions. Being agreed by that wife as preferred, MFA number 1016 of 2014 before this one.
And
respondent has filed Prop 17 of 2015. Yes, dismissal of 13-1. As the facts are put forth, he has already remarried to one Mandula alias Ramya Sri
when?
on 28/10/2009.
Any children in the, any children from this redlock?
No children.
The second marriage also no children.
Second marriage, now, year back, one document was produced that there was a child which is born,
How many?
which is
One child.
So
born.
I mean, will you go and supposing if we allow your petition, will you go and resign? It does not arise, right?
So what I find permanent alumni to be awarded by this one report by doing the time.
Ah.
He states that a child by name Anyashri was born to between the second wife in the year 2000. 2021. Anyashri was born in the year 2020-21.
So what do you do? So what do you do? Running a floor mill. So what do you say? What is your this? How much do you expect?
My offer is about 30 lakh rupees. This one he is holding 3 ancestral house at Bengaluru and more than 6 acre ancestral property where his share is about 2 acres and odd to his father's share, which is not disclosed in his affidavit also. Sadhana.
Have you find any document to show?
Yes, ma'am. She has now given a document wherein
Given a document to you.
now because there was he suppressed the material by placing assets and liabilities were suppressed. No asset, no such documents were placed by him in the assets and liabilities line in the middle of November. The property is already sold and family property, sold by other.
Three ancestral houses. What is your income, Mr.?
And your monthly expense is 50,000. Your monthly income is 20,000, monthly expense is 50,000. Why do you spend more than your income?
So how do you manage? How do you manage? If you don't have money, you earn 20,000, how do you spend 50,000? No. Yes, Mr. Be reasonable. Your husband spends more than what he earns. Then- And he's taking loan and surviving.
So let her give the property which is been share also could be affiliated or a house. There are 3 florid house about independently and one jointly along with his brother Nagaraj, which is been pledged and taken a loan of 42 lakh rupees.
You are concerned with permanent alimony, right?
Yes.
You are not a broker dealing with the
No,
property that
not-
I want this house, I want that house, and this land. So that's why.
I'm looking for the status.
So
of
you
the-
have to be reasonable, right? So his monthly income is 20,000, he's spending 50,000. So what can be done?
Please drag this one.
We can ask-
Page number 8 of the.
15 lakhs we will ask him to pay as permanent limit.
The first instance, this one, before this one report, it's a 50 lakh rupees as of this status. Now he has suppressed all those joint family properties and also properties which are held by his father and deeds which are entered subsequent to the marriages in the year 2020 and.
So Mr. Even if he is holding an ancestral property, how does it accrue to your benefit?
No, he is getting the income, but he is suppressed before
What?
this one. I can demonstrate by his affidavit itself. He takes a loan of 42 lakh rupees.
Mr. We are not, please understand, I mean, we are talking about a particular amount. We have put a question to you. Right, I mean, why should you make,
30 lakh rupees
what
would
will be the,
reasonable.
file a suit for partition if you have a share? Do it, whatever.
No share.
It's a question of permanent alimony, right? So
I take this honorable.
we will ask him to, that's what we are telling you, we will ask him to pay 15 lakhs.
30 lakh rupees would be reasonable. As of his one property worth rupees 1.5 crores. And another.
Which property, Mr.?
88.
Where is the document?
He himself has disclosed joint family properties, which is in the.
He has said that joint family means
Between two.
it
brothers.
doesn't belong to him. Right? It doesn't belong to him.
He has raised.
1.5.
It belongs to him itself. He has entered into documents. At page number 12 of the assets and liabilities, he has entered into a deposit of title deed. At page number 8 of the assets and liabilities. He takes 42 lakh rupees recently a loan and states that 30,000 would be his EMI. And further he states 50,000 rupees is his expenses. And his income would be 20 to 25,000 rupees. And the rent would be 10,000.
So how much will you pay, Mr.? No, not 7. It's on the lower side.
How many days you had stayed with him?
2 years I was staying with him.
No.
He is not.
2006 is the marriage and 2007. 2007 is the, then
So where from have you stayed with him for 2 years? In 2009 he had already remarried.
On the remarriage date itself, when I was in my parental house. I got that information and I came down. And I have given a complaint. 2009, this is weird job. It is not made a mind to be a police. 2008, my lord, I have filed maintenance application before the Devnali court, where he bypassed the Devnali court and filed divorce petition before the Bangalore court. It is also stated in his first, it is also stated that para B of that assets and liabilities itself. In 2008, I was being awarded 2,500. In 2008, I was at Devnali court filing maintenance petition. And now he bypassed that and came down to Bangalore and filed the divorce petition and obtained it. 2007 is right.
Just a minute. It's not like that he will speak one sentence, then you. What is the question involved in this appeal, according to you? So what is the question relevant for it? The only quantum, right? He's saying something I filed when Devnali, Bangalore. What? How is it relevant? We don't know. He doesn't understand anything. What can be done? At least you should understand. What? The only thing is quantum.
Quantum. Understood. But here,
So what is so difficult to understand? It has taken you so much of time. 15 minutes, after 15 minutes, you understand that only quantum of maintenance. So what is, how much should be granted to you?
30 lakh rupees would be reasonable. Not till now, yeah.
Why not 50 lakhs? Why 30 lakhs? Just and reasonable, because you are saying, why not 1 crore? Why not 5 crore? Why 5 crore would be just and reasonable.
His present income is nearly a lakh, and he has a liability of 30,000 to be paid as a EMI. Total income itself is 1 lakh rupees, so he has to pay in EMI to 30,000, and he will be saving 70,000 rupees for his rent, because he is not paying any rent. His rent agreement, what is created itself is a created one. Demonstrate. And he is living in a zone building, which are at Bangalore, Munandi.
Bangalore? Where is it from?
No.
Own house.
No. 700. Two houses are built next and next. One is for his brother, it is already encompassed. The other one, which is not encompassed as of till today, which is lying in his father's name.
Where is the floor mill? Where is the floor mill? That building is also your own building, floor mill building.
One more building is that 89/8, where he has not deposited a title deed and obtained a loan. Both are the interests. Other interests.
Last submission.
Still one. States in affidavit that his expenditure at 50. He lives in his one building and his income inflow at 20,000, including the rent of 10,000 rupees. And he's also getting one big building where 42,000 rupees loan was Father Mangala. Loan was created. Income is suppressedly placed.
This marriage, he filed insurance petition for expert or he said that he's already.
All right.
Tomorrow is before the mediation because of extension of time it has been. The matter is almost
Not
right for
settled.
settlement. 54 months.
No, mediation center has settled
Mediation
the
center,
report.
because of time has
Tomorrow
given
it is
only
there.
2 weeks.
Tomorrow.
Tomorrow is the
But it
mediation.
says the
No,
mediation
that is because
report
of
not settled.
expiry of time. It is time. Expired. Now we have to extend.
Shall we extend?
Tomorrow
10
it
days.
is, the 10 days.
Next 10 days, we tell you that. Before that, mediation. Mediation.
No, but where is the other side? You are saying
She is, because she is not within the lead, she called me and I requested her, I will mention it. But because tomorrow is the mediation, there will even will
learned counsel for the parties jointly submit that the matter can be amicably settled between the parties. It is also pointed out that the proceeding before the mediation center are fixed for tomorrow date 10th of January 23 in view of Opposes submission. 10 days further time is granted to enable the parties to arrive at an amicable settlement. Why sorry? Government comment. What?
ದೀಪಕ್ ಸರ್ ಡಿವೈಡ್ ಮಾಡಿ ಕೊಡ್ರಿ 5ನೇ ನಂಬರ್ ಇಲ್ಲ
Morning, total mode. Education.
You supplied a copy to them. Told them it's coming up. Huh? Huh. Say that this is sports quota, right? What they have done, your admission is, they have issued a fresh list. Why?
They say that I am not eligible. She got 99% degrees. Options. And 585 total hours of just 585 and 600. Even without this sports quota, only she would have joined other ones. They give the list of other persons will be selected.
Why it has been cancelled? What is the ground of? Yeah. Karnataka exam, you should have supplied the copy to Mr. Ramesh. Mr. N.K. Ramesh appears for the. So order is issued by Karnataka Examination Authority, then they have done it right. You don't supply for what to do? Where is Mr. Ramesh? You supply, we will take it up tomorrow. Hey, we don't know. For the present, we would like to hear them first. Mr. Learned Senior Counsel undertakes submit petition along with annexures to Mr. N.K. Ramesh, Learned Counsel, who appears for respond number 1. You appear or don't appear? To which result? So and so accepts notice on behalf of respond number 2. Office is directed to reflect the name of Mr. N.K. Ramesh. Yes, tomorrow. Huh?
Third respondent.
The third respondent, who's formal, we can decide on contesting is Karnataka Examination Authority, right? Find out, Mr. Why it has been cancelled. What at least you should come up with some sort of why have you done it? What is the reason?
Number 51.
He came to my residence.
51.
3rd of January, we had granted time. What again? The 30?
It says they are not,
Huh?
they have not complied. Right. After sir, he says they have not complied. Okay.
Not complied. Why we should not dismiss your appeal for non-compliance with 17B? Tell us. It's pending for past 8 years. If you don't intend to comply, why we should not dismiss? Tell us. 3rd of January, we had granted you time. When was the order, interim order passed?
17/11/22.
17/11/22. Yes. Sir, present, why we are not asking this for it? We are asking you to comply with 17B. So you are presupposing that he will commit violation and we should suo moto register contempt. So facilitate, he will be present and immediately we should give him sting notice and he will accept, right? Like that, in anticipation. So why you keep him? Why do you want to keep him present? Huh? You told us that I will keep him present. Why? So you tell us why we should not dismiss this non-compliance to 17B. Tell us. Weeks time granted, 10 days time, right? Current government advocate is granted 10 days time to enable him to report compliance with the directions contained in the order dated 17/11/2022, failing which appropriate order shall be passed. It's on 24th January 23.
Along with that connected.
Huh?
Along with that serial number 18.
Along with 22. That whatever list along with item number 50. Huh? Okay. No need to be grateful, comply with the order. The consequences will follow otherwise. We have said already that appropriate order will be passed means, you know what it means, right? But further action is taken into restriction conducted by sale of is wrong. The order. Supposing if you participate in an auction, you have a right to seek a writ to conclude the auction, accept your bid and all that. No, whatever. I mean that the property should be conveyed by way of a sale deed, can we grant a decree for a specific performance in a article? No, it's the relief is in the nature of like that. That you are an auction purchaser, you want the sale deed to be executed in your favor. Ah. Ah. So therefore, sale deed should be executed. That's the case. Yes, why you did not execute the sale deed, Mr. Huh?
With R6 along with my application.
Annexure R6. Huh?
25/11/2013 it is cancelled even before filing of the writ.
25/11/13.
Even before filing of.
So what does it? What does it say? You tell us.
2/1/2012 is cancelled. Huh? Option 2/11/2/1/2012.
11/2000.
2/1/2012.
Yes.
The government has introduced the Alamanna scheme. That is the exhibit R7A. But wherever this kind of loans are pending, the bank was directed to accept the principal amount and to pay off the interest amount. So accordingly, the original was purchased, obtained the loan. The approach to the bank and expressed his readiness to pay that whatever interest amount was pending. And that was accepted and he has paid 30,000 rupees on to the bank. And the loan was. Now and before the. We have submitted that whatever the amount there was deposited in the bank.
He was not aware of this order passed probably. Yes, subjection is filed in.
Nothing survives. It has been cancelled, right? What is that annexure R6? What is annexure R6? If it's not cancelled, then what is annexure R6? Huh? When did you file the writ petition?
2014.
2014, right? Before filing the writ petition, it was cancelled.
Issued a notice, calling upon them to confirm the sale and issue the certificate. That a reply was issued. For this on the court. Reply to the discipline was made in 2019. In that also they have not. The matter was elicited for final hearing. After hearing the matter and payment was completed. The return of the court directed the appropriate some to file the not.
Events data.
They change the address and find the affidavit, saying now producing the option can be cancelled within 30 days from the date of option. Accepting the option. As per the rule 38(5) of the law of the. Within 30 days, they have to deposit their money. Then ask for cancellation. Otherwise, it is not required. Even they had not deposited their money, nor made a new application. I had not received any notice from the minister. Now they produce the order passed to me. Order cancelling. But on 25/7/2019, the respondents 2 and 3 have filed a reply. They received it. Reply to the appeal. But they did not report about the cancellation.
You are appealing for? You will refund the amount.
Yeah, that is different. But what it is not a- But our the farmers bank where we lend it to the farmers at the 25 paise interest rate. Nominal interest we are ready to refund it. But it is kept in the.
Huh?
it is kept in the suspense.
Along with interest
I mean, nominal interest we are ready.
and what of
Because this is the bank, cooperative farmers bank, where we lend it at 25 paise per annum. Per annum, the loan will be lent the rate of 25 paise per annum.
yes.
Now, there was no mistake on it.
Ah.
We are to be- we are declared as a yes. Entire big amount of mistake. Further, but the stamp duty and the registration charges are also tolerated. On the table for awarded to the minister.
You don't have any remedy against order 25/11/13 passed by whom, Mr.?
Just got a late. Just got a late.
Assistant register. Assistant register.
Oh, appeal. Appeal lines. Hey, we don't. Get him, maybe. Yes.
Was not given any notice. Even after passing the cancellation order, as per annexure of the, I was not given, no, an order, the order was communicated. Only for the first time. Not, they can produce and do it. Not with the thing. Directed, they filed the affidavit to not complete the formalities and refuse the sales certificate. They agreed. Later on, they took 3 adjournments. After taking 3 adjournments, they changed the law and produced an affidavit reducing this calculation. Earlier, they
It's
did
not your
disclose-
case that it is a forged document or something like. Not your case.
Yeah. According to me, there was no proceedings. For cancellation, but within 30 days from the date of the action, they have to deposit the amount and seek for cancellation. As per rule 38.
Why it has been cancelled, but this auction 15/11, what is the ground to cancel it?
It's
Ah.
the market value was not obtained. But that, what extent of land was pledged for small amount of loan, very small amount. And the sales was proceedings. On that particular two, there were 2 and 2012. Not their certificate was not obtained by the publisher, not mentioned in the publisher. But and ಹರಾಜು ಪ್ರಕ್ರಿಯೆ ಪ್ರಾರಂಭವಾದ ಇಲ್ಲಿಯವರೆಗೆ ನಡೆದಿರುವ ಪ್ರಕ್ರಿಯೆಯು all the proceedings were not under as per the Proceedings Act. That is what the AR.
Implementator had not paid the fees to cancel the. He had
We
not,
got it. We got it. You are saying that once an auction is conducted, thereafter it is open for the legislator to deposit the whole amount and seek cancellation within 30 days as provided in the rules, which has not been done therefore, and they have produced it for the first time in the year 20. That's it.
and earlier also. it was not used.
Ah.
That, they want to see the legal notice. They reply. In the reply also. they
You have passed this order suo moto cancellation. However, it was.
For for confirmation. They noted the irregularity and said we cannot come.
Actually, yeah, for confirmation.
Not telling what are the.
On the other hand,
Irregularities. What irregularity? Irregularity.
That is what, value is not obtained.
Huh?
Value of the sub-register from the sub-register office, value of the property.
Ah.
And minimum value is not mentioned in the ordinance.
All right, all right.
Maybe. And the entire procedure, whatever the issuance of notice and other things has not been followed during conducting the action.
All right.
That is what the assistant registrar felt and it's been cancelled. It was not confirmed.
Action amount was mentioned. Later on, only one land was sold. 4 properties were given as security. Out of 4 lands, only 1 land was sold. Now 3,50,000. Because you not as the AS. And I.
That's it. Yes. Ah. This intra-court appeal is filed against an order dated 24 July 2014, passed by learned single judge, by which we thought that you have concluded. Or yes. Yes. Which judgment? 89-2.
Here again, the point of amendments cannot be denied on the grounds of need to enforce it. Amendments of the duty does not necessarily have to be one imposed by statute. It may be sufficient for the duty to have been imposed by common law, custom, and even common. This route, the judicial control over past standing major bodies affecting the rights of the people should not be put into automatic combat. It should remain flexible to meet the requirements of various circumstances. And must have a very wide remedy. It must be easily available to reach in the technical case will not come in the way. Granting the relief under order to do them. We therefore reject the contention for the appellant on the maintaining of the appeal. For the staff report and the first take the preliminary exception for if they maintain no other person will be report saying those with resolution station to issue to any person or by including big one. There is direction apart from this. It's in nature of this article is called comprehensive very, very power. on the High Court to reach injustice wherever it is found. The Constitution designedly used very language describing the nature of the power, purpose for which and the function or authority in whom it can exercise. It can issue writs in the nature of prerogative writs and understood legally. But the scope of those writs also is written in the use of expression nature. For the said expression does not equate writs in the issue legally with those legally. Only what not been seen. Metaphor, High Court can also issue expression of the this case, not injustice has been found. There was no mistake on the part of the claimant. He was the highest bidder. 5 persons had participated in it. He was declared as a highest bidder. Bid amount was paid. And they also collected his stamp duty and registration charge. Even after doing it, he did not perform his tax duty. Therefore, I wrote it.
That's it. Anything else?
They were not confirmed. Confirmation of the state. Because there is already cancelled. This petition before the honorable court is issued directly. Confirm this. It is already cancelled. But we got to now in view of that payment of entire amount, one amount. However, nothing survived for consideration. We were forced to accept advice that the government itself has brought R7 may kindly be considered. R7 is the issue by the government to accept the waive of the interest and accept the principal amount of all the farmers who over loan is pending. Yes, yes, paid loan amount. We are ready to, it was never been used by the bank, that it is kept in the substance. But
That's it.
the citation and that.
Need time for going through, right? Huh? Adjournment for 1 week. Huh? So one day you will read one paragraph. So I mean, 7 days you will read what are how many paragraphs? We don't know. Is this the way, Mr.? Entire burden is on the court to hear arguments, to record your concession submissions, and to pass an order. Everything on the court. You did not explain. You did not even understand his submission. Whatever has been told to you by your client, only that thing you said. That we have cancelled the auction. We are ready to pay the amount. What did he argue? He said that an auction can be cancelled only in the manner known to law. This means you did not understand, right? That's why you did not answer. And you are saying yes. We are required to explain to you what he has argued, right?
This was the case.
We don't know. Did you answer?
Here is the as the submitted by me. It is by the judgment determined for cancellation of the auction after confirmation. That is, here is a case where the file was submitted for confirmation of the auction, which was not confirmed at all. By the second respondent bank, it was submitted.
Which provision it was placed for confirmation?
Yes.
Which rule? That you should have pointed out, right? We have to explain what he has argued, then you will tell us, right? And you have to look into the judgment cited by him. You should have given him prior notice, Mr. What is this? You are citing judgments. He doesn't know what judgments. Which provision it has been? Find out. Where is it? Opening the book here only, right? In the code. No. So then why are you not telling us? Oh, very good. How can you be so unreasonable, Mr. Asking him to argue when he has not this thing brought his specs? Senior counsel. How can you be so unreasonable? Huh? So where have you left? I mean, how will you manage the day, Mr.? You come to the court and your job is reading, right? And you have left the specs. So what? I mean, how do you read them? What do you do? Roam about in this thing park and go away, right? In the evening. Huh? You come here to breathe fresh air and go back home in the evening. Then what is the specs?
You read that annexure R6, you read already? Then how did you read without specs?
No, this really, I mean, after 13 years of judgeship, new ground for adjournment I have discovered today. We feel that we have to learn a lot from you people. For the first time that I have not brought specs, that is the ground for adjournment. You could have said that I am not ready, my lord, it may be adjourned. We could have understood that. But after having argued the case, when a query is being put that I have forgotten my specs, therefore it should be taken up tomorrow. Should we write and send it to the bank who has engaged you, Mr.? Should we send it to the bank? The chairman of the bank saying that your counsel is seeking adjournment on the ground that he has not brought specs. What type of counsel you engage? Should we send it? Write in the order sheet and send it. That's why you have not brought specs. The court will do it in any ways. Farmers Bank. No, enough for you to say Farmers Bank, the court will do its job. And if decision goes against, we will file SLP and go to Delhi, right? No. No, but you must do it charity properly, right? Charity doesn't mean that you will not read the file. No. Charity doesn't mean that you will just stand up and say whatever court has to decide it with. Thank you, Mr. What can be done? We'll pass an order. We don't want to trouble you. Don't find out your specs. Be happy, be without specs now. Yes. Why? There's no need of specs. Court has specs. Court will pass an order. Right. Thank you. Don't strain your eyes, mister. It will have an effect on your health, right? Why should you trouble yourself? We have heard it. We have heard it. I told him that we will pass orders. What else? Why are you standing here? We'll pass an order. That's why we don't pass an order in the presence of counsel because of this habit of interruption. Yes. Definitely,
Order 38
I
rules.
appear for the respondent in this matter, my lords.
And you can set up
Order.
38 rules. Rule 38. 6. 38. Without even application, it can be.
Wait, one. Please wait for 5 minutes. You're not. Other counsel is gone. Why you don't have any other case? No court. An opportunity before Supreme Court. No, we are going to record this that you did not argue because specs. Mr. The case is over. He has left. Please don't take. Please leave the court. You have argued the case. We have said that we'll pass an order. Next case.
I appear for the respondent in this matter, my lords.
Is it? What?
He went to the police station to praise his father. He police received an announcement on 25.
All this object of compassionate appointment is now it's over. It's all 2002. Your father died. What's your age now?
The point is that
One of the family member is already in service.
even otherwise, I produce this honorable report.
Oh, if you have not succeeded before the learned single judge, can't get any relief. You know, the honorable judge who has passed the order. He was the most considerate, one of the most considerate judges. If he has declined relief, you should fairly say, sir, I have no case. Got it? Not applicable since a member of the is already in service. Long order providing not. What's your age? Still you are seeking compassionate appointment. Yes. You have no option. And Supreme Court doesn't need your certificate that you agree. Right, Article 141 gives them the power.
The question is, he got the death certificate only year 2011. He responded the application, but during their life, during the pregnancy, they're insisting on the death certificate. Unless I filed a suit before the jurisdictional court, after I obtained a degree from the court that he was deemed dead, I would not have. This is the only question. Thereafter, the only other note upon which my case has been rejected is that, though he was, if at all the his father was in service, he would have retired in 2006. I had obtained the certificate in 2007. Meanwhile, I had produced an DPR circular for furnishing the authority the definition of the family. Here, the circular said, and any member of the family will not stay living together cannot be construed as
Not living with you. Who has been this thing member of the?
One of the obtained a job in Excel.
He is staying away from.
Staying away.
Not supporting the family, not on talking terms, demanding money from you. Right? Yes. Thank you. Why short? Give a long synopsis. Why short? has been filed against an order dated 24th of July 2015, passed by the legislature, by which the writ petition by the appellant has been dismissed. Paragraph. What your case, you can give this paragraph. Facts giving rise to filing of this appeal. Please, that Dute Gowda had taken financial assistance of rupees 45,900 from Primary Cooperative Agricultural and Rural Development Bank in Bagal, herein after referred to, and had mortgaged land. Hearing survey number, it's all here. Number 818 plus 2 and 1 acre. Situated so it's to be respectively. Full stop. Outside Dute Gowda. Outside Dute Gowda defaulted in payment of the loan amount. Thereupon, a dispute was raised by the manager of the bank before the assistant registrar cooperative societies Polar, full stop. An award dated 25/6/1987 was passed for recovery of an amount of rupees 40,513 as on 31/3/1987. Paragraph. In pursuance of the award, an auction was held on 2/1/2012 in which the appellant was declared to be the highest bidder for an amount of 3.5 lakhs. However, 3.5 lakhs. However, despite issuance of sale certificate in favor of the appellant, sale was not executed in his favor. The appellant therefore filed a writ petition seeking a direction to the assistant registrar cooperative societies Kolar to confirm the sale in favor of the appellant and to execute a sale deed by completing the formalities for its registration. The learned single judge by an order dated 24 July 2014. 24 July 2014 has dismissed the petition. Has inter alia held that has inter alia not dismissed, it has inter alia held that the appellant is governed by terms and conditions of the notice of public auction and therefore was relegated to take recourse to such remedy as may be available to him in law for redressal of his grievance. Accordingly, the aforesaid factual background, this appeal has been filed. Paragraph. Learned senior counsel for the appellant submitted that the auction. It is submitted that the auction could have been cancelled only by deposit of the amount, only on deposit of the amount of auction by the judgment debtor within a period of 30 days. However, however, it is also submitted that the order dated 25/11/2013 has been produced for the first time in the appeal. Full stop. It is also submitted that powers of this court under Article 226 are wide enough, and the relief sought for by the appellant can be granted to him in the proceeding under Article 226 of the Constitution of India in support of opposite submissions Reliance has been placed on decisions of Supreme Court in so and so versus so and so. 1989 Volume 2 SCC 691 and so versus so and so. AIR 1966 Supreme Court 81. On the other hand, learned counsel for respondents have submitted the order passed by the learned single judge. Paragraph. We have considered the submission made by learned counsel for the parties. The auction in question is governed by the provisions of the Karnataka Cooperative Societies Rule 1960. After the auction was held, the same was put up for confirmation before the assistant registrar in pursuance of proviso to Rule 38 within bracket 6 of the cooperative societies. In pursuance of proviso to Rule 38 within bracket 6 of the Karnataka Cooperative Societies Rules 1960, full stop, the assistant registrar on perusal of the auction proceedings found that the same suffered from several irregularities as much as the market value of the property was not obtained from sub-registrar and the minimum value of the property was also not mentioned in the auction sale notice, full stop. The assistant registrar by an order dated, therefore by an order dated 25/11/2013 directed to cancel the auction held on 2/1/2012, full stop. So aforesaid Rodde Gowda was a farmer who has admittedly the amount of loan has been deposited by him with the bank, full stop. The learned single judge, full stop. The contention made by learned senior counsel for the appellant that the auction could not have been cancelled is therefore misconceived. Paragraph. The paragraph learned single judge in the facts and circumstances of the case rightly declined to grant the relief as claimed by the appellant, full stop. However, the bank is directed to refund the amount deposited by the appellant along with interest at the rate of 6% from the date of cancellation of auction till the payment is made. Right.
Petition was dismissed without notice. Therefore, the opportunity is earlier.
So misconceived you have written. Thereafter you write, so far as the contention that the order dated 25/11/2013 has been produced belatedly is concerned, suffice it to say that since the petition was dismissed without notice to respondents, therefore they have filed the aforesaid order dated 25/11/2013 cancelling the auction in this appeal. It is not the case of the appellant that such an order was never passed. Right. So, the aforesaid extent, the order passed by learned single judge is modified. In the result, appeal is disposed. Next. 3. This intra-court appeal has been filed against an order dated 18th of July 2014 by learned single judge by which petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that on 7/10/2002, order of the appellant, the appellant thereafter filed an application on 10/3/2010 to the director of Karnataka Power Transport Transmission Corporation Limited, KPTCL, within bracket, seeking appointment on compassionate ground. Filed an application, right? Give the date. The aforesaid application was rejected by Father went missing, right? Thereafter, the mother of the appellant moved an application seeking appointment in so and so on appointment in Karnataka Power Transport Corporation Limited, moving packet KPTCL, comma, which was rejected by an order dated 10/3/2021. Full stop. The appellant thereafter obtained a decree in the civil court seeking a declaration that his father, namely late Shri N. Ramaiah, is dead. Full stop. On the basis of the aforesaid paragraph, on the basis of the aforesaid decree, a death certificate was issued by BBMP, right, the whole thing, on 16/7/2011. The appellant filed a petition, namely WP number 2852/2012 within bracket S, in which a prayer was sought to appoint him on compassionate basis. Full stop. The aforesaid writ petition was allowed.
Earlier. Allowed and directed to be considered.
The aforesaid writ petition was disposed of by an order dated 19/6/2012 with the direction to consider the case of the appellant for consideration of appointment on compassionate basis. The aforesaid the KPTCL, however, by an endorsement dated 23/1/2013, rejected the claim of the appellant. Paragraph. The appellant challenged the aforesaid endorsement in a writ petition, namely WP 2457/2014. Learned single judge by an order dated 18/7/2014 has dismissed the writ petition. In the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant submitted that that appellant is entitled to compassionate entitled to seek appointment on compassionate basis. Paragraph. We have considered the submission made by learned counsel for the appellant and have perused the record. Full stop. It is strike law that an appointment on compassionate basis cannot be claimed as a matter of right. Full stop. Learned single judge on perusal of the record has found that a member of the family, namely brother of the appellant, has already been provided appointment on compassionate basis. Has already is already in service. Full stop. Is already in service. Full stop. The learned single judge has therefore found that appellant is not entitled to seek appointment on compassionate basis. Full stop. Paragraph. We do not find any ground to interfere with the order passed by learned single judge. In the result, appeal fails and is hereby dismissed.
$55. Even Siddhappa, government educate. Yeah.
Yes.
Hereafter, some of the villagers are filed appeal before the state commission. State commissioner, without there being any record. And on the ground that there are worship may get it at page. This is thought. Aspiration copy 74 page. After mentioning the argument of the both the parties, is 74. On behalf of the application, on behalf of the respondent, the counsel's written arguments is examined. And the documents available in this case. Verified. The land in question is situated in city. The totally from 1,468 taxes, totally about the it seems to be responded to the survey. It is not wrong, it is not wrong. So the land, I think I will have to do it. Taking a more easy, then we look at it. Coming from under the issue and 20 of land. So you know, in I don't know how many days, all of this and
You are holding right 4 acres and 8 guntas of land in the village.
that is incorrect. All documents are there. Even
And that is the-
are for the records, they are not produced. You are not at all holding, that is the finding of the after committee, after holding and record.
Assistant Commissioner and Deputy Commissioner have a
State that made by the villages, that has been taken note of it. No records have been taken by the even in the records, it was a committee, there was no record at all. No records have been taken.
but it's a government land, not your land, right?
And the not accurately.
So you are unauthorizedly encroach anything and then say that I should not be evicted. Why?
I am.
No, but you have the fact remains that you are in unauthorized possession of the land, government, right?
I am in question of the topic.
Government land, unauthorized possession.
And as per the rules provided by the not very, I will not. And committee, after considering the village accountant, all those things, we are holding anybody. The committee has granted 2 acres seat. Total, 2 members are there. Only with regard to the aspirant is concerned, regularization is a rule that is not coming in the real. And we see the other who in that case. Not eight.
What rule? 108I
Rule 108
of which rule?
of Karnataka and Revenue Books,
Ah,
1966.
certain lands to be not granted.
Yes, sir. Notwithstanding anything contained in this job, that is assigned to the special purpose and section 1 of that and the land. Right.
what real growth and such land which, in the opinion of the government, is required for the public allot the grant. Today, set up our public estate, such as a revenue act. No, do rights. Similar, if you got pasturage is concerned, anything at the land is concerned, it is not applicable. Here, the pasturage has been considered the authority. This is one of the and with regard to the higher holding of the land or documents, you know, all for the records from the as part now records whether have not been produced before the market. The market are dated 8/3/2022. Market has called for the record.
Yes,
So
madam.
AGA is getting records.
Huh? There is an order. 8th of March 22 were almost how many? 10 months ago. So then why are you arguing this? You should have said that there is an order directing after having argued the case. I mean, so why are you arguing again? You should at the beginning you should have said that there is an order. They have to produce the record. Why you have told us? What's the finding here in this place? Lakshmanpalli village. Lakshmanpalli village is there. Andhra Pradesh. Where from the government will produce the record with Andhra Pradesh?
That is their case. Andhra Pradesh is talking about the secretary is the order of the committee.
So that is Madam Lakshmanpalli village is in Andhra Pradesh. Right? Where from will you get the record? Which provision it is required 3 years cultivate? One more. Okay. Yes. Yes, wait. How many? 30?
She is a language lady, does not have any language in village. And so
Capital A and Karnataka land.
Yes.
How land to be granted has been stated in regarding compensation of unauthorized occupation.
It is all committee.
So, there, my lord, we got pasturage is concerned, this is the problem, when they are entered, they can grant the land. It is apart from the section 97, you are not trying to see after provision of section 94A. Provided that land to be granted together with the land already held, such persons will not be exceed 2 hectares of this. Equivalent, provided further no mention granted to the areas lying within the limits of cities. That is the restriction before the section 93. So then, while we also read it on our 8I, no restriction in this case does not applicable. Therefore, the considering on the grounds of clear, there is no even document to show that it is reserved for free pasturage. That is survey number 31 is reserved for free pasturage. There is no document. No document is produced. One is the village says it is for the village purpose. It should not grant it. It is villages. There, this is considered. And because I am one of the lands at Andhra Pradesh, and what documents are being produced with the villages or maybe government authorities before the government. They are having a object, the pay objection for the committee. Here in also they are not produced. There afterwards before the
Here also. Even before the deputy commissioner, they find the appeal. They are not, even before in the statement, in the single date, they have not filed the statement of objection or produced the document in this regard. Even before this appeal, in this also they have not produced. If they really show it, I consider that it is there. What document is there? To show that I am holding the land.
Are you not required to prove that you have been
I am
cultivating possession? No, are you in cultivating, were you in cultivating possession? 14 for
and then doing. That produced by the village, they are not cultivating.
But what material have you produced to show that?
If in the the Wahoo, the observation and when the photograph produced by the applet,
It had been recognition that it does not own any property in that village.
You say,
I don't see it.
not cultivated. Let it go. Takes up the photograph. Not any revenue records. And they are finding recorded revenue more than this not share. They have an opportunity to provide objection because they can be granting the land, they call for the objection from the relator. No objection. Even before the state solve this. They did not even produce before or not. So my solution is what it is. The reasoning assignment on this. In RTC, index of plant, both documents reserve. Even in a 108, it clearly was four plants. Not with regard to field pasture, 377 is not applicable. That is the provision statement. Even in section 94, a provision also fits. So under these circumstances, my submission you have to fit the observation of the customer report on second that is incorrect, actually incorrect, and also like the other thing can see. But on the basis of the saying that is the only fact finding, it will more. That's right. A driver was para 7 of the language change. The assistant commissioner and deputy commissioner both found that there is no report before them about the extent of the release and the application and who had planned to read not the rectification and cultivation of the absence of the committee could not have assumed that they have not sufficient for the. This is not at all discussed in this before the appellate court also, appellate court in second. This question is not at all coming before the first appellate court and second appellate court. In the absence of the report, the committee could not have assumed that they were not in sufficient orders. Notwithstanding I have Congress, the deputy commissioner concurred with the reasonings of given by the assistant commissioner and found no occasion to vary the same. It is therefore, it is dismissed in the appeal and the appellate authority had found as a matter of fact, not only that it is sufficient to it, but also as that available global land was not adequate to the raising of village. It cannot be said to be orders of. This is not factually not there in the both the first appellate court order and the second appellate court order. Therefore, my submission to the lordship. If Malaram may make let the matter may be resolved, let the verify the facts of the case, because facts are not at all verified by the first appellate court. So then let them verify it and pass order. Therefore, my submission to the lordship is that both actually in fact.
That's all. Thank you. That's all. 57, Sri Jagdish Shetty.
Dismissing the factor, either speaking for driver, the 13 was
Wife had appeared.
Paper publication.
Wife had appeared before the family court.
Before the
Fight that you have not been able to make out the ground. Not interested.
Petition 31A and 31B. Not fitting the. Only see one given.
Election. So when the marriage has taken place,
28 March 2005.
so when did he leave the matrimonial?
28 June 2010.
And when have you filed it?
Notice issued to the respondent on 11 April 2011. And thereafter, he failed to amend one matrimony. Petition was filed on 30th January 2013. From 28/6/2010, 2 years.
Fight has been rejected. What is the reason?
As far as the registry is concerned,
Which paragraph?
11.
What has
Page
the
number 11. Noted that the notice he did not appear before the court. The burden lies on the petitioner to prove the ground alleged by the petitioner for divorce. Pleaded in his petition and also in his evidence that the respondent was guilty. Document evidence before the court.
But what you had said adultery also.
You're not setting.
Issue. Yes, even notice he did not respond. When the petition proceeded. There is an individual.
All. It will be dismissed. Yes. Thank 55. WP 3069/2020. This intra-court appeal has been filed against the order dated 19th of August 2013. Single page by which a rectification by the appellants has been dismissed. Paragraph facts giving rise to filing of this appeal. stated that the applicants claim to be claimed ED claimed to be an unauthorized occupation and cultivation of land measuring 4 acres and 38 quintas of survey number 31/1 of Ubalapura village, Chalakere Taluk, on Chitradurga district. Full stop. The applicants made an application. Applicants claim to be in whatever claim to be in unauthorized and
Unauthorized occupation and cultivation of land bearing.
so and so since 1990, right? Full stop. Since 1990, full stop. The applicants made an application before the committee for regularization of unauthorized occupation. Regularization of land in their favor. Regularization of land in their favor before the committee for regularization of unauthorized occupation. Full stop. The committee, by an order dated 11th of January 2002, approved the grant to the extent of land measuring 2 acres and 38 quintas of land. Full stop. The full stop in pursuance of the order, continuation there. In pursuance of the order passed by the committee, the Tehsildar passed an order in favor of the appellants on 11th of January 2002. Paragraph. The aforesaid order was subject matter of challenge before the assistant commissioner was assailed by respondent number 4 in an appeal before the assistant commissioner Chalakere, who by an order dated 19/1/2002 inter alia held that the appellants were not in cultivating possession of the land in question and the same was left barren. Full stop. It was further held that the appellant number 1 had a holding of held land measuring 1 acre, 4 acres and 8 quintas in Lakshmana Palli village, Charakere Taluk, and found the appellants to be not entitled to land in question. Accordingly, the appeal was allowed. Full stop. Paragraph. The appellants challenged the aforesaid order in an appeal before the deputy commissioner, who by an order dated 28/9/2011 dismissed the appeal preferred by the appellants. The appellants challenged the said order in a writ petition, which has been dismissed by learned single judge by an order dated 19th of August 2013. In the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant. Paragraph. Learned counsel for the appellant submitted that there is no material on record to show to demonstrate that the appellant number 1 is the owner of land measuring 4 acres and 8 quintas of land in Lakshman Palli village, Chalakere Taluk, so and so district. It is further submitted that Rule 108 within bracket I of Karnataka Land Revenue Rules has no application to the facts and circumstances of the case. It is further submitted that the Committee for Regularization of Unauthorized Occupation has rightly found the appellants to be entitled for regularization of the lands in question. So on the other hand, learned counsel for respondents have supported the order passed by learned single judge. We have considered the submissions made by learned counsel for the parties and have produced the record. Full stop. admittedly, a person in order to claim regularization of the land is under Rule 108F, capital F, of the Karnataka Land Revenue Rules, is required to prove that he is in cultivating possession of the land in question for a period preceding 3 years from 14/4/1990. Full stop. The instant case, the uh, the assistant in the instant case, the assistant commissioner Chala Kere, as well as deputy commissioner have found that appellants have failed to prove the fact that they were either in cultivating possession or were in occupation of a land preceding 3 years from 14/4/1990. Full stop. The opposite finding of fact is based on material available on record. Full stop. The appellants have not produced any have not produced any evidence or record to prove the aforesaid fact. Full stop. Full stop. It is also pertinent to note that the land in question is a Gomal land and is required for the purposes of grazing of the cattle.
Land. For grazing.
Land in question is a government, not Gomal land, government land, and is required for the purposes of grazing.
As there is no sufficient
Uh,
Gomal land.
Grazing of the land as there is no sufficient Gomal land. Full stop. The full stop, the assistant commissioner as well as the deputy commissioner have also recorded a finding that the appellants are the owners of land measuring 4 acres and 8 quintas of land in Lakshmana Palli village, Chalakere Taluk, so and so district. Full stop. The assistant commissioner and the deputy commissioner, which are the fact finding authorities on the basis of material available on record, have adjudicated the entitlement of the appellants for regularization of the land in question and have held that the appellants are not entitled for regularization of the lands. Of the aforesaid finding cannot be said to be perverse or based on no evidence. Of the learned paragraph, the learned single judge, on the basis of meticulous appreciation of evidence on record, has concluded that appellants are not entitled to allot for regularization of the land in their unauthorized occupation. The aforesaid findings of fact does not call for any interference in this intra-court appeal. Line below in the result, we do not find any merit in this appeal. The same fails. Yes, 57. It's appeal. The section 28 of the No Marriage Act has been filed against order dated 25th June 2024, passed by the family court, by which petition filed by the appellant seeking dissolution of marriage on the ground of desertion and cruelty has been dismissed. Paragraph. Facts leading to filing of this appeal briefly stated that the marriage between the parties was solemnized on 28/8/2005. Full stop. It is 28/3/2005. Full stop. After the marriage, the appellant and the respondent resided together for a period of 2 years and the child was born to them. However, it is the case of the appellant that respondent was having illicit relationship with other persons. and witnessed the same. And the appellant himself witnessed the same. Full stop. It was further, full stop. A panchayat was convened on 2/8/2009. However, the respondent did not mend her ways. Full stop. Paragraph. According to the appellant, the respondent left the matrimonial home on 28/6/2010. The appellant thereafter got a notice issue. The appellant thereafter sent a notice to the respondent on 11/4/2011 and asked her to join the matrimonial home. However, the respondent did not join the matrimonial home. The appellant thereupon filed a petition seeking dissolution of marriage on the ground of cruelty and desertion on 30th/1/2013 before the family court. Paragraph. Yeah.
This is not issued to join the home, legal notice issued for joint petition, mutual consent.
Acha. Legal, so you say legal notice was issued. That's all. Notice was issued for dissolution. Dissolution of marriage. Notice dated, not asking her to join the matrimonial, right? Notice was issued for dissolution of marriage. However, despite receipt of notice, aforesaid notice, the respondent did not join the matrimonial like that. The appellant examined himself and exhibited 5 documents which were marked as exhibit P1 to P5. However, despite service of notice, the respondent did not appear in the proceeding before the family court. The family court therefore proceeded to decide the matrimonial rights by a judgment dated 25th June 2014. The family court inter alia held that the appellant has failed to prove a ground of dissolution of marriage on the ground of cruelty. However, the family court did not examine the ground in relation to ground pertaining to desertion and dismissed the petition filed by the appellant. Being aggrieved, this appeal has been filed. Paragraph. Learned counsel for the appellant submitted that the learned judge of the family that the family court grossly erred in not considering the contention raised by the appellant with regard to dissolution of marriage on the ground of divorce. It is further submitted that from the evidence on record, it has duly been proved that the respondent had deserted the petitioner for a continuous period of 2 years prior to filing of the petition. Stop. Paragraph. Even in this appeal, despite service of notice,
Evidence was uncontroverted.
Even in this appeal, despite service of notice, none has appeared on behalf of respondent. Paragraph. We have considered the submissions made by learned counsel for the appellant and peruse the record. Admittedly, a full stop. From perusal of the record, it is evident that the marriage between the parties was performed on 28/3/2005. From the evidence of PW1, who has not been subjected to any cross-examination by the respondent, it is evident that respondent had left the matrimonial home on 28/6/2010. Thereafter, the appellant served a notice. Appellant served the notice on the respondent seeking dissolution of marriage. Despite service of notice, despite service of the appropriate notice, the respondent did not join the matrimonial home. After a period of 2 years, that is on 30th January 2013, the appellant filed a petition seeking dissolution of marriage on the ground of cruelty and desertion. Paragraph. In the facts and circumstances, it is settled in law that when the other side leads no evidence, very slight evidence A little, no. Where other side leads to evidence, comma, very little evidence is required to discharge the burden which lies on a party initially. In the instant case, in our considered opinion, comma, there is no plausible reason to disbelieve the uncontroverted testimony of respondent, even otherwise appellant, uncontroverted testimony of the appellant. Full stop. On perusal of the statement of the appellant in its entirety, comma, the ground of for dissolution of marriage on the ground of desertion is clearly made out. Full stop. The family court, however, has full stop the respondent, despite service of notice, neither appeared before the family court nor has appeared before this court. Full stop. In the facts and circumstances of the case, the family court ought to have granted a decree for resolution of marriage on the ground of desertion. Paragraph. The impugned judgment and decree insofar as it rejects the claim of the appellant for dissolution of marriage on the ground of desertion is set aside. The marriage between the parties formed on 28/3/2005 is dissolved by a decree of divorce on the ground of dissolution of marriage or on the ground of desertion. To the aforesaid extent, the judgment decree passed by the trial family court is modified and the results appeal is partly allowed. Oh, trial. Trial court. For 58, the Shivra, the listener, what is appearing for respondent? So let's see tomorrow. For 59, the case Rahul Kariyappa. Pass over, madam. Nobody is for responding. 67 days. The Kalimpura city.
My lord, this case for the appellant, my lord. Now the respondent is trying with settle the issues in the presence of presenting the parties, my lord. I request, my lord, have it next week.
So we'll grant you time to report settlement, right? What date? 24th January. Generate counsel for the parties jointly pray for adjournment to enable them to report settlement list on 24th January.
Great.
23. Huh? Where do you submit in the High Court documents? We are not concerned with ready or not ready. Either you should have filed it or you need. Do we need to tell you what prayer should you make before the court? That also we should tell you, madam. One case an adjournment was sought that he has forgotten the specs. Now I'm in a step further that we need to tell you what we want. Ready means what? And ready is ready. Fine. Go ahead, Mr. She is ready. Go ahead.
Petition filed by the husband, husband. Ex parte harm.
So, madam, you have not filed a statement of this thing, assets, liabilities. You have not filed, and we are proceeding ahead with the arguments, right? The inference is obviously against you if you don't file. Go ahead, Mr. It's ready. It's ready. Why you were keeping it with you? Why you did not file it, madam? What prevented you? When it was ready? When it was ready? So why you did not, the matter is listed today. What you did from 10:30 till 4:15, please tell us. Do you need all the petitions are filed, everything is filed with our permission? Take it up then. We don't know whether you can file it now. You can file it.
4 o'clock is the last one. 4 o'clock. What? Tomorrow is it?
Tomorrow you file. You should say so, madam. Whole day you are only sitting to seek an adjournment that it's ready, right? That's the tactic. What else? What prevented you from not filing it from 4:30 till 4 o'clock, 1:30 till 4, 10:30 till 4? What prevented? If it was ready 3 days ago. You just wanted to ensure that it should not be taken up. If at all the number is called, I will seek an adjournment, right? That's the attitude.
Yeah.
Why they are? No inconvenience. What is their inconvenience? Yeah. Great counsel for respondent prays for adjournment to enable her to file an affidavit regarding statement of assets and liabilities. At this stage, learned counsel for the applicant submits that he is not available on account of personal difficulty. List day after tomorrow. Huh? There no negotiation. Huh?
What was the offer? Your client is in Dubai. In Dubai. Wait.
And as per their own case, they got an affair with another man, who got delivered a child. And thereafter, this is the second marriage for them. Me also now is the third marriage.
You did not take any lesson from your previous two.
Degree. Our marriage is saying that because of their illicit relationship or love affair, they have taken certainly child. Thereafter, they not married. They have documentation there. By mutual consent, they obtain the.
Where is Mr. Shastri? Password.
Earlier marriages, you have not paid any permanent alimony.
Paid the permanent.
Earlier marriages also.
So let him come.
And Gautam Raghunath?
Yes.
Not cooperated for physical contact. And he has made many representations to the various authorities. Therefore, he has not. Marriage. He is in the other way. He explained the subject duality in the hands of the husband. The other day I read a judgment. Now I will take
On the last occasion, you submitted that if you will be satisfied if alimony is granted to you. No, judgments are not required. If it is only the question of alimony, we'll ask them what is the alimony they will pay. You are happy if the alimony is granted to you. That's what the submission you made.
So what do you say with regard to permanent? So how much you are and in addition 6.5
In addition, education and marriage.
education and marriage expenses also.
Before the AIDS consulting she has 50,000 rupees. Used to take money from the sick man. And she even she said.
So what is you seek instructions on this offer, Mr. You heard.
Classification is that
Find out, seek instructions, we'll take it up tomorrow. You have heard, right, learned senior counsel saying that 15 to 20 lakhs and 6.5 lakhs for your daughter.
education and marriage expenses
Ah.
separately.
And education and marriage expenses.
Have you claimed? Have you claimed, Mr. Till date, have you claimed? Have you filed an application seeking maintenance for yourself or for your daughter till date? But till date, there is no order in your favor.
Seek instructions, Mr. So you agree that
6.5 lakhs she has deposited separately, not as per.
separately for the daughter? Yes.
Virtually, it would be a restitution order after 2019. She came once with four relatives who look more like bouncers and bakers, do not drink but water rather.
No, we have asked her to find out with regard to the possibility of settlement. Why do you want to make all this? Sir? Why do you want to make all this? Sir? No, if you want to argue, we will decide it on merits. Then we have asked him to find out.
Yes, now we eventually agreed for permanent ceremony. We just want to ascertain you have given the offer. Let him respond tomorrow. Number 64, Bhushan Kumar, H.C. Shivram. Yes. On the ground, duality.
Both of them are making allegations of externality in Egypt. And the court states that it is in our.
What's the point in contesting this litigation, Mr. You should think about. Yeah, I mean, both of you cannot stay together even if we dismiss, allow, whatever, do, whatever, right? What?
He's employed that way, he's ready to leave.
Ready to live with her. Huh? But you are unemployed, right? So what will you do? I mean, if she comes. No, but you yourself think about it. Sir. I mean, that is it. I mean, possible, like living together after this much of litigation, nature of allegation is, does it? No. In short, we should decide it on merits, right? Huh?
Understanding that what you want to be like, we find it.
Good.
They have to make up their mind.
Yeah.
I have made up their mind. Whatever is part, they have said, you have said. This is forget and leave. They don't want to.
Don't want to. That's why this appeal. Yes, yes.
The VA also. The VA, they are all
Alright. Fine. Yes, yes, madam. That's why is.
Even in Delhi, you are taken to Delhi. You are here. So he did not get his job. He cooperated. Help to settle the life.
Let her argue.
Yes. They have. They did not have
physical relationship also since 2016 to 2018. In 2018, they were separated. ನನ್ನ ಕಂಡ ಕೆಲಸದವರೊಂದಿಗೆ ಅನೈತಿಕ ಸಂಬಂಧ ಹೊಂದಿದ್ದನ್ನು ನಾನು ನೋಡಿಲ್ಲ. ಈ ಸಂಬಂಧದ ಎಲ್ಲಿಯಾದರೂ ಗುರುತಾಗ್ತಿಲ್ಲ. ನಾನು ನನ್ನ ಹೆಂಡತಿ ಯಾರಿಗೂ ಹೇಳಿಲ್ಲ. ಅದಕ್ಕೆ ನನ್ನ ಹೆಂಡತಿ ಮನೆ ಕೆಲಸದ ವಿಚಾರವನ್ನು ಮಾಡಿದ್ದರಿಂದ ಅದೇ ದಿನ ನಾನು ಮನೆಯಿಂದ ಹೊರಗೆ ಬಂದಿದ್ದರೆ ನನ್ನ ಮೇಲೆ ಹಲ್ಲೆ ಮಾಡಿದರು. ಮರಣದ ಮೇಲೆ ಒಡೆಯಲು ಪ್ರಾರಂಭಿಸಿದರು. ಆಗ ನಾನು ಜೀವ ಆಚೆ ಬಂದನು. ಈ ರೀತಿ ಯಾವುದೇ ಹಲ್ಲೆಯನ್ನು ಮಾಡಿಲ್ಲ, ನಾನು ಸುಳ್ಳು ಹೇಳ್ತಾ ಇದ್ದೇನೆ. This is the reason why the husband and wife separated on that day. The allegation made against her is that she started hitting on that day. And the reason for hitting him is that she came to know, she tried to move. That is the reason why that is the reason what he has. ಇಲ್ಲಿ ಯಾವುದೇ ಹಲ್ಲೆಯನ್ನು ನನ್ನ ಮೇಲೆ ಮಾಡಿಲ್ಲ, ನಾನು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ. ಯಾವ ವಿಚಾರ ನಾನು ಮನೆಯಿಂದ ಹೊರಬಂದಾದ ಮೇಲೆ ಮನೆಗೆ ಹೋಗಿ ನನ್ನ ನಿಕಟಿಗೆ ಚೆನ್ನಾಗಿ ಇರುವಾಗ ಹೋಗಿಲ್ಲ. ನಾನೇನು ನನ್ನ ನೋಟಿಸನ್ನು ಕೊಟ್ಟಿಲ್ಲ, ಅದರ ಕಾನೂನಿನ ಪರಿಜ್ಞಾನ ನನಗೆ ಇರಲಿಲ್ಲ. ಅರ್ಜಿದಾರರು ವಿಚ್ಛೇದನ ಅರ್ಜಿ ಹಾಕಿದ್ದ ಬಳಿಕವಷ್ಟೇ ನಾನು ಹೇಳಿದ್ದೇನೆ, ಅದಕ್ಕೆ ಅವಕಾಶ ಕೊಟ್ಟಿಲ್ಲ. ಈ ಹಿಂದೆ 2-3 ಬಾರಿ ಈ ರೀತಿಯ ಇಲ್ಲ ಎಂದು ನಾನು ಮನೆ ಬಿಟ್ಟು ಬರೋದಕ್ಕೆ ಮುಂಚೆ ನನ್ನ ಹೆಂಡತಿ ಯಾವತ್ತೂ ನನ್ನ ಮುಂದೆ ನಾನು ವಿಚ್ಛೇದ ತೆಗೆದುಕೊಳ್ಳುತ್ತೇನೆ ಎಂದು ಹೇಳಿರಲಿಲ್ಲ. ನನ್ನ ಹೆಂಡತಿ ಮೃದು ಸ್ವಭಾವ ಎಂದರೆ ಮುಂಗೋಪ ಜಾಸ್ತಿ. ನಾನು ಮುಂಗೋಪಿ ನಾನೇ ಅವರ ಹಲವಾರು ಬಾರಿ ಹಲ್ಲೆ ಮಾಡಿದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನಾನು ಗಂಡನಾಗಿ ನಿರ್ವಹಿಸಬೇಕಾದಂತ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಇವತ್ತಿಗೂ ಶಾಲಾ ಫೀಸನ್ನು ಮತ್ತೆ ಇತರ ಎಲ್ಲಾ ಖರ್ಚನ್ನು ವೆಚ್ಚವನ್ನು ನನ್ನ ಹೆಂಡತಿ ಭರಿಸುತ್ತಿದ್ದಾಳೆ ಎಂದರೆ ಇವಾಗ ಅವರೇ ಮಾಡುತ್ತಿದ್ದಾರೆ. ಮಗುವನ್ನು ನೋಡಲಿಕ್ಕೆ ಮತ್ತು ಖರ್ಚನ್ನು ನಾನು ಭರಿಸುತ್ತೇನೆ ತಿಳಿಸಿ ನೋಟಿಸ್ ಅನ್ನು ಕೊಟ್ಟಿಲ್ಲ. And he has not paid. He himself has admitted that he has not paid any money to in the examination in chief itself. He has stated that telephone number constraining me to reside in my ancestral house. It was only thereafter I came to know the illicit relationship of the petitioner with the above said Sri Mallikarjun. Their conversation were also recorded with the member of the family of Sri Mallikarjun, and it is only then I gained information visiting the house of Sri Mallikarjuna in the advance of his life. It is in this background that petition has been preferred, making uncharitable allegations against me. He has not stated that Mallikarjuna wants to marry me or anything. he is my brother's younger brother. Just to only after I filed this petition here. And he said that he, you cards are my becoming a assistant professor in state with and he said that and even the complaint given in the Mathur police station could not be not. Some sort of agreement between husband and okay, this lady with confidence that she wants great. It's impossible for anyone to say. And he being the daughter of the principal of the college. And she was younger, this lower grade, they married each other. And after he is not.
Now she is repenting. Yes. Yes, but anything else? That's it.
Kindly be granted a place letter peacefully, let him not make allegations. Approach others in the.
Case is not some of the what which I made. I was also working in the PhD office in order for some time. Time of marriage. Now, what she said is not because of my experience always regarding job. It doesn't mean to say that I influence the police also not to be digital. It cannot be the one. Because after the marriage, I could not continue in the APS job. I went to my village. I settled in my village. As I was returned, part of the elderly. Then, by staying at in the village itself, all these examinations, etc., other progress not able. It doesn't mean to say that I demanded 28. It's not none of demanding me. I myself is a graduate. I was working in APSR. I sacrificed my little life to work progress because I am really qualified than me. This is the reason I show so much of indulgence by going through various horrors. To see that you should occupy a when such an attempt has been being made in a reasonable effect, then they say that now, because she doesn't want to stay in my village, because she has become a state professor. That is the mistake which I have made. You are not supported in her endeavor to become a lecturer or professor or something. It would have been happy, like you have been happy. It is the mistake made by me to see that let my wife was since she is a qualified lady let her occupy a good post. Since I am having a related to some family, I will help her. It resulted in this video. I have never in my secondly, by her personal claim of sweat for delivering the child parent love. But what available the pay. Secondly, he herself borrowed the house at Metro. He is staying there. So produced to her. The only thing is not the allegation she has set up against me. I am living in a village. Where is the question of why my village? I can understand if it is there. In village, There is no maid servant available in the village. And because he wants to escape from the marital home, he started making this kind of allegation against me. That's why I'm moving with the maid servant. There is no maid servant in the village. My mother.
And there is no principal of the college also. No maid servant, no principal of the college. So therefore, the question of saying that you want to continue, we'll hear you tomorrow. Tomorrow, madam.
ನಾಳೆನೋ ಏನೋ ಬಹುಶಃ ನಾಳೆ ಬರುತ್ತೆ. ಹೋಗ ಅಲ್ವಾ.